For reasons mentioned in the judgment, this criminal petition is dismissed. And the contempt case is directed to be listed before appropriate bench.
May I pay for listing of this civil division petition IO minor tomorrow for motion minor. The next date fixed is on 6/7 minor.
Okay. Okay.
But
May I please your lordship, it's a fair for listing a matter. This is the FAO against the order of rejection of junction. Lordship, there's an urgency, so matter may come up tomorrow. Lordship.
Day after tomorrow.
I have a similar prayer for listing C as well.
Day after tomorrow.
May I please, Lordship? I'd like to mention one CRP matter. I don't know, IO is also there, Lordship, after summer vacation. 22nd.
Yeah, please, your lordship. Lordship, I'd like to mention for listing of a FAO, your lordship. Friday, possible, lordship.
Okay.
Lordship,
Okay.
much of it. Yeah, please, lordship, beg to mention item number 28. Lordship, we are filing Wakaratnama today, appearing for respondent will be Borwa. Kindly, please for some time.
You have informed the other side.
Yes.
Have you informed?
Inform other side, I'm not sure, I'll ask him.
We'll pass orders when the matter is called. Wait for your turn.
And please, Lordship, I beg to mention for listing of a matrimonial appeal on Friday, Lordship.
What is the urgency?
Lordship, the petition is agreed by the granting of permanent alimony, Lordship. That is
After vacation. 17 July.
Friday, Lordship.
No.
May I please, my lord, I am for item number 22, my lord. On behalf of Learned Senior Counsel, P.K. Chaudhary, my lord, he is out of state on that matter may be adjourned for that day.
Mister, what is your name? What is your name?
S.R. Borwi.
S.R. Borbhuya. Learned Counsel appearing on behalf of Mr. P.K. Roy Chaudhary seeks an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. The prayer is allowed. Let this matter be listed on 31st July.
Interim order is there.
Interim order is there.
Yes,
You have verified.
yes. Interim is there, it may be extended.
The interim order shall continue till next day.
I beg to mention for listing of the case, madam, that is arbitration appeal against the section 14, madam. The next date is on 27, madam. So kindly tomorrow or day after tomorrow, madam.
Day after tomorrow.
Yes, madam. May I please, your Lordship, I beg to mention item number 23, Lordship, for withdrawal, Lordship. Lordship, matter was filed for modification, Lordship, but now appellant does not want for further proceeding, Lordship. Item number 23 and 25, Lordship.
What is your name?
J. Kolita.
Heard Miss J. Kalita, Learned Counsel for the appellant, who prays for allowing the appellant to withdraw this instant appeal. The prayer is allowed. This appeal is dismissed on withdrawal. Similar orders in 23 and 25.
Yes,
Separate orders. Separate.
I will list your lordship. Lordship, MLC appeal number 289 and MLC appeal 8335/23. Ma'am, lordship, matter will be listed on Friday.
What is the urgency?
Lordship,
What is the urgency?
lordship, due to the financial problem of the claimant, lordship.
After vacation.
May I please, your lordship, item number 6 FAO 29 of 2026. With the consent of the petitioner side, I beg to mention item number 6 of today's list that we have filed Wakaratama for respondent number 1, 2, and 6 yesterday. So we need 2 weeks time to file.
You have informed the.
Yes, I am
Okay.
appearing for the appellant, your
Okay.
lordship. They have
What is your name?
Below here.
We heard Ms. P. Longley, Learned Counsel for the respondent, who submits that the Wakalatnama for the respondent has been filed today only, and some time is required to seek instruction from the respondent side. Also, Mr. What is your name?
Hey, Das, your lordship.
Hey Das, Learned Counsel for the appellant, who does not raise any objection against the prayer of the learned counsel for the respondent. Hence, same is allowed. Let this matter be listed. 27 July.
My lord, there is an interim in the.
The interim order shall continue till next date.
Obligation.
May it please your lordship, I beg to mention item number 36. My senior won't be able to conduct the court today because due to some medical emergency. So
You have
kindly,
informed the other side.
lordship, there is no name in the side of the
Third
respondent.
Miss, what is your name?
D. Goswami on behalf of R. Goswami.
Third Miss D. Goswami, learned counsel for the review petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. The prayer is allowed. Let this matter be listed 13th of July, 31st July.
Obliged lordship.
I'm back to my item number 9. It is, the matter we taken up another date because from brief with along with my junior colleague, he went to the Hyderabad for his mother treatment. That I could not prepare and
Third Mr. L.K. Bora, learned counsel for the appellant who seeks an adjournment on the ground of personal difficulty. The prayer is allowed. Let this matter be listed 29 July. Yes.
May I please to lordship, I beg to mention for listing lordship. Civil religion petition lordship, any date after vacation.
My lord, please. My lord, I'm mentioning a matter for listing, my lord. It's an IA for withdrawal of the money which has been deposited with an registry, my lord. Can it be on the Friday, my lord?
Okay.
Deep look, Mr.
May it please your lordship. Lordship, I beg to mention for listing of RSA lordship for orders.
After vacation. 27,
Lordship, may it be on 24th,
24th July.
deeply obliged.
Therefore, listing of an IA, your lordship, in an RSA may be listed on Friday for condemnation of delay. Notice can be issued to the court.
Yes, Friday.
My lord, item 52, supplementary list. We have to file 2 IAs, but party did not come to put signature in affidavit. So let the matter be listed after vacation any day.
You have informed the other side.
I will inform. He has not yet come, Mr. Chaudhary.
We'll allow this, but not now.
Hello?
We'll allow this, but not now. When the matter is called, we will allow.
Thank you, my lord.
Yes.
My lord, আজকে আমি কিছু অর্ডার দেখাতে চাই। 8টি অর্ডার আছে আইএ পিটিশনের মধ্যে, যেটার মধ্যে দিয়ে আমার কেসটা কেন জরুরি এটা সবকিছু ওইখানেই মেনশন আছে। তো আইএ পিটিশনের ফার্স্ট 49 পেজ একটু যদি দয়া করে আপনি
You don't have a counsel.
নো
We will engage a legal aid counsel for you.
লিগ্যাল এইড কাউন্সিল পার্টি ইন পারসন।
Because the language you amicus curiae list. We are appointing one amicus curiae to assist the court.
Yes, 0 last hearing.
Oh, one amicus curiae has been appointed. Where is he?
0.
Okay, we'll take it up after some time. Tutul, Jero, phone koriman. You wait for some time.
Wait, please, Your Lordship. In the earlier occasion, Your Lordship put question on the maintainability of my CRBC, Your Lordship. I have not found any. So the matter may be decided on merit, Your Lordship.
What question was raised?
On the maintainability of CRBC. Whether it is CRP or second appeal.
What is your answer?
My lord, the impugn order is not a decree on merit, Your Lordship. That is why in my CRP only.
Okay, we are keeping the
Impugn order, Your Lordship, only see page number.
no, we are keeping the option of maintainability, question of maintainability open.
Whether
We are issuing notice.
CRP.
Yes, we are keeping this. Heard Miss A. Begum, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner impugning the order dated 17/3/2026 passed by the Court of London Civil Justice
Senior division.
Senior Division. In which case?
In Manishu, in Midze case 4 of 26.
Why have you not mentioned it in the cause title?
Is
Where is you have mentioned the order dated so and so. Passed in which case?
in Midze case.
Where is that?
It is in page number 58, Your Lordship.
That you have to mention in the cause title. Where is the impugn order?
This is the impugn order, Your Lordship.
Which page?
Page number 58. 58 to 64. Corrective portion, Your Lordship. Page number 64, Your Lordship. 63, 64.
In Ms. J case number 4/2026 by the Court of London Civil Justice Senior Division, North Lakingford. Though a question as regards maintainability of the instant revision petition was raised by the court. However, learned counsel for the petitioner submits that keeping the question of maintainability open, notices may be issued. Hence, let the notice be issued to the respondent. Keeping the question of maintainability of the instant petition open, the petitioner shall take steps for issuance of notice upon respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on July 31st July. List accordingly.
May I please, Your Lordship? Your Lordship, basically, I'm assailing the order passed in section 36 of the Arbitration and Conciliation Act.
26.
36 is for enforcement of an award, Your Lordship. What has happened, if I may just be permitted to place the brief facts, Your Lordship. If Your Lordship wants to say the impugn.
Where is the impugn order?
Yes, Your Lordship. 133. 178.
34.
No. 178. It starts at 178. Your lordship may skip and come directly to page 185 and 185. Paragraph 6, your lordship, at page 185. I've heard the learned counsel for both the side at length. Am I with your lordship?
Yes.
Paragraph 6. I've heard the learned counsel for both the side at length. The instant petition was filed by the learned counsel for the award holder party to modify the order dated so and so. In the said petition, this is not correct, your lordship. In the said petition, the learned counsel for the opposite party inter alia has prayed to allow him to withdraw the amount of rupees 7741,660 deposited by the petitioner arbitral debtor. Yes, during the course of hearing, we did make a suggestion that allow us to withdraw this amount. And in this, he has relied on the following judgment of the Honorable Gauhati High Court to buttress his claim. Then 7, your lordship. After hearing the rival contention of both the parties and the observations of the Gauhati High Court vis-a-vis the relevant provision of the arbitration, I'm of the considered opinion to modify the order passed on 34/2025 with the following effect. The stay granted by the said order will be enforced until further order. The opposite party holder is at liberty to withdraw the 50% of the deposited arbitral award by furnishing an unconditional bank guarantee. This is basically, at this moment, I'm agreed by this direction. Your lordship, my proposition of law as the Supreme Court, your lordship, may just see one judgment.
Well, what is the order dated 34/2025?
34 is in the, yes, your lordship, I'm just coming.
Page 133.
133, your lordship may see.
Yes.
And the operative portion is at page 134. Also seen the petition number 1848 filed by the petitioner, that is the respondent.
Okay, 100% was directed to be
The
deposited.
100%, if your lordship just turn for a moment to page 116 page.
One.
6. That's the operative portion of the arbitral award.
Yes.
Paragraph 2, your lordship says, an amount of rupees 7747. Your lordship may kindly mark that amount, 7747,660. So the 100% will be 7747,660. Impugn order, your lordship has seen, the amount is 7741. So one of our stand was this, that since you have not deposited the 100%, in terms of the order of 34/2025, the order stands vacated. Impugn order, your lordship may again see. In the beginning, page 186, top. 7741,660. And the fact that they have deposited this amount is also apparent from Annexure 4 of the court, order dated 21/6/2025, page 135. Order sheet of 130 at page 135 may also be seen.
Yes.
So, your lordship, what happens is here two things, your lordship. If they have not complied with the order of 34/2025 fully, then the order of 34/2025 stands vacated. The stay granted ceases. In that eventuality, I am entitled to go and initiate execution proceeding. We suggested, okay, since the amount is anyway lying there, let me be permitted to withdraw this amount. A Guwahati High Court, Your Lordship, has been consistently saying that allow withdrawal of the amount by furnishing indemnity bond or solvent security. My thing is that when a higher court have been issuing a particular direction,
Okay, we are issuing notice. Heard Mr. D. Senapati, learned counsel for the
notice to
petitioners. This application under Article 227 of the Constitution of India has been filed by the petitioners, Messrs. Assam Steel Enterprise, impugning the order dated 12/3/2026 as well as 34/2025 passed by the Court of London, Civil Justice Senior Division, Number 1, Kamrup Metro, in connection with Arbitration Case Number 26/2025, whereby the operation of arbitral award dated 18/1/2025 passed by the sole arbitrator in PCB number 1 of 2018 was stayed till the disposal of misarbitration case number 26/2025, and the present petitioner was allowed to withdraw the 50% of the deposited amount subject to furnishing of bank guarantee to the tune of equal value. Stop. Issue notice to the respondents.
Your Lordship, the BSNL is the party. Advance copies were already served upon them. They have standing counsel.
But no one has appeared.
Yes, no one. Their name is also shown in the counsel, standing counsel. Name to know, standing counsel. But anyway, we will.
You furnish requisite copies.
I'll do that, Your Lord.
It appears that though learned counsel for the petitioner has submitted that the advance copy of the notice has already been furnished to the standing counsel of BSNL. It also appears that name of the standing counsel BSNL is reflected in the cause list. However, the learned counsel for the petitioner is requested to furnish requisite numbers of extra copies of the petition along with annexures to the learned standing counsel of BSNL. Let this matter be listed.
17th of July, Your Lordship, because the next date is 21/7.
On 17th of July. List accordingly.
Interim may be considered on the next date.
What interim?
Either to say this or allow me to withdraw by alternative means. That will amount to
That will amount to the final.
Mother.
Okay, alia matin.
Item 46 from supplementary is.
May it please, yes, my lord. My lord, here we are assailing an order whereby, my lord, my application for impeachment that was rejected.
Application for
Implement as defendant number 7 in the suit was dismissed, my lord. I'll just narrate the brief facts of the case, my lord. The respondent number 1 herein, my lord, they institute a suit for declaration, cancellation of the mutation of
we issue notice.
my lord.
What is the next date?
Next date is 17/7, my lord.
Before that date, we will fix.
My lord.
Heard
Immediately
Mr.
on reopening, my lord.
Heard Mr. G. Imtiaz.
A.
Learned-
Iqbal, my lord.
Sorry, A. Iqbal, learned counsel for the petitioner. Also heard Mr. N. Alam. Appearing
for respondent number 1.
learned counsel for the caveator slash respondent number 1. Also heard Mr. T. R. Gogoi, learned counsel appearing for respondent number 2 also. Today you can inform the standing counsel. Appearing for respondent number 3, 4, and 5. It is submitted by Learned's Government Council that number as regards respondent number 1, the Standing Council Revenue Department, not Standing Council Revenue Department, namely Mr. J. Hendick, may be notified. Respondent number 2 may be notified. Issue notice to the other respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 16th of July. You have received the 16th of July.
Look, next date is fixed on 17/7 for commissioner's report. Evidence has already started. So may I pray, my lord, till at least next date, my lord. If evidence is completed, my lord. it is
No, we are fixing it before
before
16th, that 16th of July.
16/7.
16th. The petitioner shall furnish requisite number of copies of the revision petition along with annexures to the Learned Government Council within 2 days from the date of this order.
May I please, Lordship? Lordship, the impugn order contained in my lord page 50. No, 65, my lord. My lord, the brief fact of the case in nutshell is that, my lord, there is a dispute between landlord and tenant. Now, my lord, there is a ex parte decree against the tenant. I was the defendant there. And my lord, being agreed, my lord, we have preferred an application under Order 9 Rule 30. While we prefer application under Order 9 Rule 13, this application was not allowed, and accordingly, my lord, we prefer appeal. Now, while we prefer appeal,
Why it was not allowed?
my lord, because the condonation petition that we
What?
have supported, that was considered along with the merit of the case. Therefore,
Delay was not condoned.
yes, and prior to that, my lord, merit was considered. Therefore, we approached before the appellate court. Appellate form remanded back the matter to consider the issue of limitation. Then, my lord, go to the merit of the case. Now, while my lord, this proceeding was ongoing, then on particular date 19/2/2024, a date was fixed, but we miss out the date 19/2/2024. Now, on the next date, my lord, 22/2024, the matter was again posted, and on that day, my lord, the petition which we have preferred, that was dismissed, my lord.
Order 9 Rule 13
Yes, my lord.
petition.
So therefore, my lord, to recalling that petition, we have prepared an application, and that application was registered as miscase 242 of 2024. Now, my lord, the other side is also, my lord, contested the matter, and finally, my lord, 19/3/2026, this impugn order was passed, where, my lord, this application, where we have prayed for recalling of the order, my lord, 22/2024 was rejected. Hence, my lord, this revision petition. Now, lordship, kindly, sir, legal issues are there. My lord, I'm not going to touch any disputed facts, either this or that side. They have made their own case, I have made, but legal issues, lordship, kindly see for a moment. Lordship, just look paragraph 11 of the impugn order, CPC there. Now, it was the pleaded case of their side in paragraph 11. It is contended the present application is not maintainable under Order 9 Rule 10 CPC, as the dismissal in question was under Order 9 Rule 8 CPC. According to the opposite party, the appropriate provision for restoration in such a case is Order 9 Rule 9 CPC, and therefore the present petition liable to be rejected on the ground of maintainability. But they have taken a ground that in my case, Lordship kindly see Order 9. There are three provisions which I am referring here. Order 9, Rule 6 deals with once plaintiff appear, defendant fail to appear. Order 7 deals with, my lord,
Yes.
defendant appear, plaintiff didn't, if not appear. 9 about, my lord, restoration part, my lord. So therefore, my lord, two provisions are important. Once, my lord, if defendant fail to appear, and if you want to, my lord, recall the order, then it attracts Order 9, Rule 7, my lord. In case of, my lord, plaintiff fail to appear, then, my lord, for the purpose of restoration, Order 9, Rule 9 is applicable. Now, lordship, can you see prima facie the plea which they have taken that in such a situation, Order 9, Rule 9 is applicable. Lordship, this rule is applicable in case of plaintiff. I was there, my lord, defendant. Now, lordship, kindly see paragraph 14. On merit, it is contained that the petitioner have grossly negligent in prosecuting the case and has also remained absent on 19/2024, the date of immediately preceding the date of the dismissal. It is argued that the ground taken by the petitioner, such as wrong notice of death, alleged technical glitches and heavy rush to the court, are vague, unsustainable, and do not constitute sufficient court. It is further submitted that no material has been placed on record to substantiate the alleged technical glitches in the court.
Mr. Khattar, will you be filing any objection?
My lord, two issues are, my lord, legal point are only two issues, my lord. My lord,
On maintainability of this revision application, my lord, we can. Because in my respectful submission before your lordship, is only the appeal lies. And if for 1 second, if I can take your lordship to paragraph number 16, which they have made at page number 9. Paragraph number 16 of page number 9 of the memo of revision application, my lord. He himself admits to that. Being aggrieved.
Paragraph 16.
Paragraph number 16, my lord, appearing at page number 9.
Yes.
May I read, my lord?
Yes.
Being aggrieved by and dissatisfied with the judgment and order dated 19/3/2026, passed in Misja case number 242/2024, the petitioners have preferred the present revision petition filed under Order 43, Rule 1C, read with Section 104, seeking interference of this Honorable Appellate Court and restoration of Misja case number 212 to the so by their own admission. My lord, the appeal lies, in fact, and rightly the appeal lies, but they have, though mentioned in this application, my lord, that the appeal lies, but they have filed the revision application and that has been registered as I. In both the applications, the nature is same. So if your lordship desires, then we can make an application also, I mean, affidavit also regarding the maintainability of this revision.
No problem.
Fine.
Lordship, kindly see in this paragraph more particularly, we have specifically placed, no, this is wrong, my lord. Revision petition and the body of the petition itself shows 227 you have attracted, my lord. Now, lordship, under this circumstance, lordship, kindly see, once appeal lie, my lord, my order 13, order 9 rule 13 application has been disposed of. It is not that kind of situation. Here is a case, my recalling petition has been disposed of. There is no any remedy provided in the CPC. Therefore, revision, my lord, is only the remedy which I can, my lord, avail, my lord. And second aspect, lordship, kindly see that two situation is very important.
No, by the impugn order,
Yes.
your order 9 rule 13 application was disposed of.
No, my lord, kindly see, lordship. That is the important aspect. Lordship, kindly look the last part of the petition. It till yet nothing has been done, my
Okay,
lord.
we issue notice, let them file the objection.
My lord, they are the execution stage, my lord. My lord, at any moment, my lord, that they may take the recovery of that position, my lord. Then nothing survives. Therefore, my lord, that, my lord, order is required to be stayed, my lord.
Regarding stay,
As your lordship pleases. Because out of the 4 rooms, 3 rooms they have already handed over to us. Only 1 room is.
Therefore, my lord, my is a cancer patient, my lord. This is the only livelihood, my lord. Lordship may only consider that aspect.
heard Mr. S. Chamaria, learned counsel for the petitioner. Also heard Mr. A. Sattar. You are appearing as caveator, appearing for sole respondent.
Yes, my
Sole respondent.
Appearing for sole respondent. This application under Article 227 of the Constitution of India has been filed by the petitioners impugning the order dated 19/3/2026 passed by the Court of London, Civil Judge Junior Division Number 1, Kamrup Metro, in Ms. J case number 242/2024 in connection with Ms. J case number 212/2017 in connection with title suit number 13/2009. Stop. By which the trial court declined to restore the proceedings of title suit number 13/2009. Ms. J case.
But 265 of 2007.
Ms. J case number 212/2017. As well as Ms. J. They have not mentioned it.
Well,
The other matter one.
Connected.
connected.
Ms. J case number 2, common order. Ms. J case number 265/2017. Stop. Learned counsel for the respondent submits that the present application under Article 227 is not maintainable and seeks leave of the court to file an objection, written objection raising the question of maintainability. The prayer is allowed. Let this matter be listed. Putul. On 3rd of August. In the meanwhile, since learned counsel for the petitioner has submitted that the respondent has already initiated execution proceeding on the basis of ex parte decree. Execution proceeding.
This is not an inter-party, my lord. In absence of it.
Okay, we will decide.
Yes, my lord.
That we will decide.
Thing is there, my lord. Thing.
I'm not mentioning anything.
Anything, my lord. No, intra-party, how we are absent there. That's why order 13, my lord, petition we filed, order 9.
Being a title execution case number
6/2019, my lord.
6/2019. The proceeding of the said title execution case shall remain stayed till next returnable date. List record.
Another is a similar matter,
Name.
item number 48.
Title execution case is
Arising of the same case, my lord. Parties are different only. No, my lord, the party in another case is different party. And we have filed two petitions, my lord.
in next item same order, only in place of
Case number different will be
in place of
case at 68, my lord.
in place of miss case
243.
24. In earlier case, the miss case number was
My lord, that is the Mizje case number 243 of 2024 filed in Mizje case number 265 of 2017. Page 68, my lord.
miss case number change. I'll check the orders.
No, my lord. Actually.
Similar, same orders,
Yes.
except the miss case numbers.
Yes, my lord. Page 68, otherwise, my lord, indicates, my lord.
Okay. Yes, Mr. Roy.
My lord, I'm sorry,
What
but
is this?
name was not there, so I couldn't have the postman.
You have to assist the court. Now, what is this?
All right, so far I remember, my lord.
This has been re-nomenclated as,
Yes,
earlier it was filed as a WPC. Have you gone through the,
my lord, I did have the brief manner, but so far I remember this is an ex parte order. The petition has come. So plain and simple is that matter. That ex parte order should be vacated and he should be heard, my lord. That is the only thing. But I don't have the papers, my lord, right now, my lord. Or if you lordship take it after some
you
time.
go through the brief, go through the records, or we may direct the registry to give you.
No, I have. Last occasion, everything was provided.
Okay,
But lordship may take after some time, my lord. My chamber is there, I'll get the records, my lord.
okay. We'll take it up at 2.
My lord.
2.
But not two, my lord. Right now, my lord, I'll get the record, my lord.
Okay. After some time.
After some time.
Okay.
Orders, item 30.
Or lordship may fix a date also, my lord, because then I can assist. On 20th July, my lord.
Yes.
28 July, 20 July, 21 July, 20 আমার প্রবলেম আছে 21, 22, 23, anything, 28, 29, 30.
Third, Mr. J. Roy, Learned Senior Counsel, and amicus curiae, appointed by this court by its order dated 14/5/2026. The petitioner, namely Shri Pinak Chandra Deb, is also present in person before the court. It appears that this case was earlier filed as a writ petition under Article 226 of the Constitution of India. However, in pursuant to the direction of this court, by its order dated 14/5/2026, the same has been converted into a civil revision petition. Stop. Today, learned senior counsel, learned amicus curiae has prayed for some time so that he can go through the brief, go through the records before making his submission. The prayer is allowed. Let this matter be listed
29th July, madam.
on 29th July.
Obliged.
None has appeared for the appellant on call. Let this matter be listed after vacation on a date to be fixed by registry.
Item number 14, Lordship. On last office note, Lordship, dated 22/6/2026, Lordship.
Yes.
AD card in respect of respondents, Lordship, some respondent that is not returned, Lordship. Regarding usual process, Lordship, I'll take steps within 2 days, Lordship, that I have missed that one, Lordship. I've taken steps by speed post already, Lordship.
Heard Miss P. Bhattacharya, the learned counsel for the appellant. Also heard Mr. R. Sharma, appearing for
Legal error of respondent number 1, madam. 1 Roman 3.
appearing for respondent number 1,
Roman 1 to 1 Roman 3.
1 within bracket Roman 1 to 1 within bracket Roman 3. On perusal of office note dated 12/6/2026, it appears that the service report in respect of notices issued to respondent number 2A to 2D by speed post is awaited. The learned counsel for the appellant prays for some time to take steps for issuance of notice upon above aforesaid respondents by usual mode also. The prayer is allowed. The petitioner shall take, the appellant shall take steps within 7 days, returnable on 5th of August. The registry is also directed to place before this court the postal track consignment reports of notices issued to above mentioned respondents by speed post on the next date fixed, list accordingly.
Regarding next item, Lordship kindly take up IA 677 of 2022, Lordship. This is a delay condonation petition, Lordship, respond number pre-expired. Last order, Lordship, 9/6/2026, passed by this honorable court.
Yes.
Thereafter, I have not found any office note, Lordship, after that, Lordship.
Heard Miss P. Bhattacharya, learned counsel for the appellant. You are appellant?
Yes.
Appellant. Also heard Mr. R. Sharma, appearing for respondent number 11 to 13. It appears that though the registry was directed to place postal track consignment report of notices sent to the above mentioned respondents before this court. Notice is sent to above mentioned respondent by speed post before this court. However, same has not been done. Registry to comply with the direction issued in paragraph number 3 of order dated 9/6/2026 and place before the next date fixed. List accordingly on 5th of August.
16.
Please, Your Lordship. In this case, I am to file a substitution petition, Your Lordship. Principal respondent number 2 died, Your Lordship. So his legal.
So what happened in this appeal, Lordship, principal respondent number 2 expired in the year 2020, Lordship. And the delay condonation was allowed in the year 2022, Lordship. And in 2024, I had filed an application for substitution, Lordship. Means it came to their knowledge in 2024 that respondent number 2 has already expired, Lordship. Last August, the Honorable Court directed them to file.
Some more time may be granted. Your Lordship.
2007.
Otherwise, appeal has already been abated.
In respect of respondent number 2 only. Two only. And this matter, Lordship, when the delay condonation was allowed by this Honorable Court, we went to the apex court also, Lordship. Our SLP was dismissed with a request to expedite the hearing of the appeal, Lordship. 2017 appeal, Lordship.
The appeal against respondent number 2 has abated unless you file an application for setting aside abatement. The appeal will proceed. When will you file?
Okay, some time may be granted, Your Lordship.
Time was
In the
already.
meantime, I will file. After vacation, it may come, Your Lordship. In the meantime, I will file.
Let me say Begum, learned counsel for the appellant. Also, Mr. M.K. Hussain, learned counsel for respondent number 1, who submits that the respondent number 2 has expired in the year 2020.
26/3/2020, Lordship.
2020, that is 20 within bracket 23/6/2020, and the said fact was made known to the appellant in the year 2024. However, till date, the appellant has not taken any steps for setting aside abatement. The appellant, learned counsel for the appellant, seeks some more time for filing application for setting aside abatement. As apparent from the submissions made by learned counsel that this appeal has already been abated in respect of respondent number 2. Hence, though the prayer of learned counsel for the appellant is allowed, same is allowed with a rider that in the event the appellant fails to take appropriate step, the hearing of this appeal will proceed with, as the appeal has already been abated against respondent number 2. List this matter again. 12th of August.
Item 17.
Please, Your Lordship. Your Lordship, AD card has been received with no signature. However, Your Lordship, service report regarding the usual process hasn't been received. Your Lordship can await for service report.
Heard Mr. S. Datta, learned counsel for the appellant. Also heard Ms. M. Bora, learned counsel appearing for respondent number 2. On perusal of the office note dated 22/6/2026. It appears that the ID card sent along with the notice to the respondent number 2 has been received back without any signatures thereon. However, service report in respect of notices issued through usual mode is still awaited. Registry is directed to place the postal track consignment report of notices sent to respondent number 2 by speed post. Stop. As regards the service report in respect of notices sent through usual mode, await further. List this matter. 3rd of August.
That's all. Notice upon respondent number 2 and 3 have come unserved.
Third, Mr. N. Borwa.
Yes, sir, on behalf of N.
S. Saraf, appearing on behalf of N. Borwa, learned counsel for the appellant. Also, Miss D. Goswami, appearing on behalf of Mr. R. Goswami, learned counsel for respondent number
HDFC.
respondent number 1. On perusal of the office note dated 11/7. Office note dated 22/6/2026. It appears that notice issued to respondent number 3 has returned back with a postal endorsement insufficient address, whereas service report in respect of notices issued to respondent number 2 is still awaited. The appellant shall take fresh steps for issuance of notice upon respondent number 3 by speed post by giving proper address therein within 7 days from the date of this order, returnable on 12th of August. The registry is 12th of August. The registry is directed to place the postal track consignment report of notice issued to respondent number 2 by speed post before this court on the next date fixed. List accordingly.
Thank you.
May I please, Lordship, unserved notice in respect of respondent 2 and 3, my lord, received back, my lord. They are not necessary party. Actually, my lord, we have filed appeal on the ground of quantum only, my lord.
Who are 2 and 3?
2 and 3, owner and driver, my lord. So they may be struck off from the list, my lord. And LCR received.
Third, Ms. L. Sharma, learned counsel for the appellant. Also, Ms. M. Khan, appearing for respondent number 1. On perusal of the office note dated 22/6/2026, it appears that notices issued to respondent number 2 and 3 have returned back without service. Stop. The learned counsel for the appellant submits that since this appeal has been filed by the insurance company, mainly agreed with the quantum of compensation awarded to the claimants / respondent number 1. The presence of respondent number 2 and 3 may not be necessary for deciding this appeal. Hence, she submits that names of respondent number 2 and 3 may be struck off from the memo of appeal. The prayer is allowed. The registry to strike out the names of respondent number 2 and 3 from the memo of appeal. Since the records of the concerned MSC case, that is MSC,
That TCR has already received. It will be fixed for hearing loss.
MSC case number 118/2017 have already been received there. This matter may be listed for hearing. Accordingly, list this matter for hearing
Oblige.
on
Oblige.
24th September.
May I proceed? My lord, the office note dated 5/9/25. My lord, respondent number 1 is already appeared. And 2 and 3 already received. ID card already received.
Heard Mr. R.C. Paul,
So
the
service is complete.
learned counsel for respondent number, learned counsel for the appellant. Also heard Mr.
Yes, Arafat.
S. Arafat,
On behalf of
S. Arafat, appearing on behalf of Mr. N. Borra. On perusal of the office note dated 5/9/2025, it appears that the ID cards issued to respondent number 2 and 3 have returned back with signatures of one Midul Ali, who has received the notices on behalf of the said respondent. Who are 2 and 3?
That's the owner and driver, my lord.
The notices are accordingly held to be duly served. The records of the MSC case have not yet been received. Hence, issue reminder for the records from the concerned tribunal, the registry to take steps for issuing reminder. Let this matter be listed 17th of August.
Item 21.
May it please your lordship. Your lordship, this appeal can be fixed for hearing.
Heard Mr. S. Dutta, learned counsel for the appellant. Also heard Mr.
Yes, Rahman.
Z. Rahman, learned counsel for respondent number 1. The records of the
Received, your lordship.
trial court has been received, and this appeal is ready for hearing. Accordingly, let this appeal be listed for hearing on 29th September.
Item 24.
May it please your lordship, in respect of respondent number 3, we have taken steps by Dusty Service and we have also filed an affidavit. 1 and 2 anonymous appeal.
Notice has been served.
Yes, you're right.
I was appointed amicus curiae
Amicus.
for 1 and 2.
Okay. Heard Miss P. Fukon, the learned counsel for respondent, learned counsel.
Delay petition, your lordship.
Okay, applicant. Also heard Miss R.D. Majumdar, who was appointed as an amicus curiae to defend the cause of respondent number 1 and 2. It appears that notice issued to respondent number 3 has been served by Dusty Mode, and in to that effect, an affidavit in compliance has also been filed by the appellant. The notice to respondent number 3 is accordingly held to be duly served. Yes, how much delay?
67 days.
But lordship, the explanation, I find it missing. Lordship will pay with paragraph 2, I'll read it. That the judgment was passed in paragraph 1 is 12/7/2023. That your humble petitioner begs to state that after receipt of the certified copy of the judgment, so Lordship will note they already received the certified copy of the judgment from the dealing advocate. The company had sought for legal opinion from one of its senior panel advocate. Lordship, this I do not find in their annexes. That there, because in the annexes they have given, there it is mentioned from the dealing advocate. Lordship, Annexure 1, Lordship, page 9, they say it was legal opinion of dealing advocate. So, Lordship, the time from July 12th, and they do not mention when they got their certified copy, so I'm taking it as 12th July. From 12th July to 16/10, Lordship, that is July, August, September, October. More than 3 months. The limitation in WC cases are 2 months, 60 days only, Lordship. And it had already passed. And that explanation is missing, Lordship, that part of explanation.
Lordship, paragraph 3, we have duly explained, Lordship, the delay is due to procedural delay.
Let her complete.
So, Lordship, after that, what they say is that while later dated 16/10/20, all of a sudden they say in October, the letter dated so and so was given to the council, and then again there, I think that is a typographical mistake down below. Lordship will see. In the meantime, there was puja vacation and present council was out of station and reached Gauhati on 2/10/23 only. So, Lordship, that is, I do not know if it's typographical mistake or what, Lordship, but that is before 16/10/23, Lordship. Another few days were required for drafting the memo of appeal as well as vetting the memo of appeal and present condonation petition. So, Lordship, explanation is not there. I do not mind the days 67, but there has to be proper explanation, Lordship. It is missing because already the delay time was over. And they got the opinion from the dealing council only. They have mentioned in the petition that from senior counsel, whose senior counsel, that letter is also not annexed. But from their own annexure, we find that, Lordship, page 9, annexure 1, learned to be based on the legal opinion of the dealing advocate that the award amount passed by the learned tribunal is not proper and reasonable. That dealing council's letter also they have not annexed, but from their other document, it is here that he had given the opinion, fine. But then
Where is that opinion?
that is not annexed. Neither the dealing council opinion nor the in paragraph 2 they have mentioned senior panel advocate. Those are not there. And from July they jump straight to October.
Yes, Miss Fukun. The judgment was delivered on 12th of July. So 12th of September, your limitation ends. From 12th of September to 16th of October, you have not explained this. That she has pointed out.
Lordship, may I pray your Lordship to take up the matter after some time, Lordship? After some time, Lordship.
It will change the facts.
Yeah.
And the facts only, Lordship.
We will dismiss it.
Lordship, after some time, may we have it?
Facts won't change, Lordship. Facts are before Lordship.
Lordship, PG woman appearing in this matter is on legs, Lordship.
Okay, we'll take it up after some time.
Lordship.
Item 26.
May I please, Your Honor? Lordship. Lordship, my senior is in another court, Lordship.
You're for
My lord, inadvertently, my lord, we have not filed objection, my lord. So some time is needed, my lord.
okay. Heard, Mr. What is your name?
Uh-huh.
What is your name?
Piyuddin.
Heard, Mr. Tiuddin, appearing for Mr. S. Ahmed, learned counsel for the applicant. Also, Miss L. Sharma, learned counsel for the respondent, who seeks some more time for filing written objection. The prayer is allowed. Let this matter be listed 7th of August.
Provision.
Item 27.
May please, let's say application for condemnation of delay, my lord. Delay is very long, my lord. 2,548 days, my lord. In challenging the matrimony, my lord, judgment hereby, my lord, the divorce was not allowed, my lord. My divorce petition was dismissed, my lord. So, my lord, here, my lord, the
You're opposing
Lordship, it's a huge
a
delay.
huge delay.
7 years of delay, Lordship. Also,
How have you explained it?
Well, first thing is that, my lord, he's a very poor person, my lord. We have annexed his identity card, my lord. He is a laborer, my lord, annexer 4, my lord. And during the year 2012, my lord, he is also paying some maintenance amount to the wife also. And his mother was also under treatment, my lord. And his father also died, my lord, in the year 2015. So the family had some financial problem mainly. So there was some.
No, but divorce was filed by whom? You.
Divorce filed by my.
So you know about the date of death.
No, yes, I know about the date. I know about the date.
Where is the explanation?
The explanation is, my lord, starts from annex pair number 456, my lord.
Mhm.
the
Yes.
explanation that they have cited that the applicant's mother is not well, was not well. She was ongoing also treatment. But Lordship, if you see the annexure C, the reports of the medical reports, it's all normal, Lordship. The heart echocardiography report is also normal, and
Now the impression, my lord, impression part is there. In page number 10.
What is LVH?
My lord. For many years, my lord, they are living separately.
Whereby judgment dated 12/4/2018 passed by the London District Judge Jorhat in title suit number 54/2012, whereby the suit for divorce filed by the present applicant was dismissed. Learned counsel for the petitioner has submitted that the assignment report of notice issued to respondent number 2 before this court on the next date fixed. List this matter 3rd of August.
Obliged, Lordship.
30 and 31.
My lord, as per office note dated 22/6/2026, my lord, notice to the respondent number 2 and 3 is awaited. And notice to the respondent number 1 is returned with unserved notice because the address left the place. So, my lord, after obtaining the proper address of respondent number 1, and
Heard Mr. B.R. Das, learned counsel for the petitioner. On perusal of the office note dated 22/6/2026, it appears that notice issued to respondent number 1 has returned without service with endorsement within inverted comma, addressee left from the said address. Whereas notice service report in respect of other respondents is awaited. Learned counsel for the applicant prays for some time to find out the proper address of the respondent number 1 and then to take fresh steps for issuance of notice on the said respondent. The prayer is allowed. Registry is directed to place before this court the postal track consignment report of notices issued to respondent number 2 and 3 on the next date fixed. Please this matter 19th of August.
Item 32 and 33.
My lord, office note dated 22/6/2026. Notice to respondent number 2 is served, my lord.
And one,
One, my lord, see the order dated number 6/5/2026. On that day, the learned advocate Ms. L. Sharma was appeared for OP number 1.
okay. But Mr. B.R. Das, learned counsel for the petitioner, office note dated 22/6/2026 shows that
I am not in this case, my lord. I have to get instruction from the company, my lord. AGCK is there, no?
you appeared,
Earlier I am appearing, my lord.
you take instructions.
Yes.
Office note dated 22/6/2026 shows that notice to respondent number 2 has been duly served, as same has been received by wife of the respondent number 2. On the other hand, Ms. L. Sharma, learned counsel for the insurance company, submits that she has not yet been engaged by the insurance company to appear in this review petition. However, she seeks leave of the court to take necessary instruction from the insurance company in this regard. The prayer is allowed. Let this matter be listed again. 19th of August.
Yes.
I'm taking a short break. Appear in this revision petition, and he would be filing his wakalatnama shortly.
Yeah.
Today itself. You'll be filing any objection? He submits.
Go through it, but I've not got it.
He submits that some time may be granted to him to take proper instructions from the respondent side. The prayer is allowed. Let this matter be listed 3rd of August for admission hearing.
Major.
Obligation.
Item 45.
May it please your lordship. This is a review application, my lord. While I'm aware of the limited scope of the review, I seek the review on the ground, my lord, that neither the trial court or the appellate court took into consideration the material evidence as well as material evidentiary circumstance also. At the moment, to persuade this honorable court, I talk about exhibits 20 to 47. These 27 exhibits which had a material bearing to the issues, especially issues number 2 and 3, were not at all discussed. And since the trial court as well as the appellate court did not discuss, perhaps this honorable court also did not have the occasion to consider that part of the evidence while considering the revision. And not having discussed these material exhibits in my respectful submission, the conclusion arrived at was not at all correct. And the issues that were all decided against me while holding that I have the plaintiff could not discharge the onus. And when I have given not only oral evidence supported by material evidence, and that material evidence is not discussed at all, no finding given at all, in my respectful submission, the conclusions arrived at both by the trial court as well as the appellate court cannot be sustained. And in my respectful submission, without there are number of other circumstantial material evidence also. Just now I'm not bothering this honorable court, at least to persuade this honorable court, exhibits 20 to 47, which are at page 276. These
Review, the scope of review is very limited.
yes,
What is the ground for review?
that the ground that material evidence, documentary evidence was not taken into consideration at all by any of the courts, including this honorable court, while deciding the civil revision. And if a material evidence has been ignored totally, that in my respectful submission goes to the root of the matter and giving a ground for review. This is my respectful submission. And these
You can take this ground before higher court.
my lord, when material evidence,
when review lies.
when a material evidence is gone unnoticed, that gives the power of review. A jurisdiction reason to exercise power of review. If it would have been a wrong conclusion, a wrong decision, a wrong finding, or maybe whatever it would have been, if it would have been noticed, discussed, then appellate court perhaps, which my honorable court.
But this order under review is an order passed in revision, that too after revision of the appellate's court order.
That's right. Exactly. That is what
So-
my point. What I'm
so
pointing out. None of the three courts. None.
No, the last court need not to go into evidence at revisional stage in detail.
It need not exactly. But whether this fact was noticed, that the exhibits 20 to 47 was not at all noticed. Whether this fact was taken on record by any of the court. Neither the trial court, neither the appellate court, they did not even notice that these exhibits were there and that it required any consideration at all. Exhibits 20, 20 to 47.
Whether it was pleaded.
It was pleaded, oral evidence was led, and this material evidence also was produced. It was a clearly pleaded case. Else I would not have come for review. I would have said that if there is any grievance, perhaps a higher court, as this honorable court has right.
We are issuing notice.
I'm grateful, my lord.
Heard Miss B.S. Goyal, learned counsel for the review petitioner. This review application under Order 47, Rule 1, read with Section 114 of the CPC, has been filed by the petitioner, Mrs. Assam Trade Agencies, praying for review of the judgment and order dated 4/5/2026, passed by this court in CRP number 97/19. Issue notice to the respondent. the petitioner shall take steps for issuance of notice.
For
We-
interim protection also.
What interim protection?
Let the judgments arising out of the title suit one.
Whether any execution case has been filed.
That we have not received notice, but we have checked that there is a execution proceeding filed.
When is the next date?
When is the next date?
This date.
On 30th
Of,
this month.
you have not received any notice.
This what is the petition?
Diligently. By speed post as well as by usual mode, within 7 days from the date of this order, returnable in on July. No, on 12th August, no, 31st July. 31st July.
From the CIs that I see, it is title execution 14 of 2026. But it is not part of my pleading because till then I had no information about it.
Then you make,
I will do that since I know about it. But in the meantime, let the judge, if the judgments and decrees are stayed, my
judgment and decree cannot be stayed. Execution has to be stayed.
yeah, I'm making a statement at the bar that we have come to know that title execution of 14 of 2026 has been filed. Or any execution arising after these proceedings may not proceed, my lord. Some protection may be given, my lord.
Learned counsel for the petitioner submits that in the meanwhile, the opposite parties and the respondent has already initiated an execution proceeding, that is
Title
title
execution
execution
1
case number
of 2026.
1/4 of 2026, and she prays that till next returnable date, the further proceeding of the said title execution case may be stayed. The prayer is allowed.
I'm grateful, my lord. Title execution before Civil Judge Junior Division number 2.
Pending before the Court of Civil Judge Junior Division number 2.
Kamrup
The
Metro.
prayer is allowed, list accordingly.
I'm grateful.
May I please, my lord? Here in this case, lordship, respondent number 1 and 2 were not represented by according this honorable court engaged Madam R.D. Mozumdar in this case.
And she is
as a
opposing
pro bono
vehemently.
counsel, lordship.
No, lordship, because fact.
You have
they
not-
filed in November, not even October.
Lordship,
They filed the case
I'm
in
coming
You
to
have
the
not
delay part.
explained.
I'm coming to the delay part later on, lordship. Firstly, lordship has to decide. I have intimated my company, lordship, but what happened, lordship, madam is also employed in our company. So she cannot take both the parties, lordship. There is
Lordship,
that is
this
bar,
is friend
No,
of-
she's
Lordship.
not,
but they
she's
are
only
objection, lordship.
assisting.
Since she is also employed with us, how can we protect our interest?
No, I am.
Now she is
friend of the-
objecting, lordship. We have come with a clean hand that we want to settle this case. We were trying to contact the
No,
parents of this case.
Mr.
No
Burman,
means, lordship.
she has not been appointed as a
Lordship, that
legal,
is okay.
listen to me.
I have voiced my concern.
First, listen to
I'll be
me.
instructed by the company, lordship.
She has not been appointed as a legal aid counsel to, she has been appointed as an amicus curiae to help the court. And that can be done by any counsel. And in that capacity, she has pointed out that
I have no concern, no objection on that, because I have raised this objection raised by my appellant company, my client, lordship. That's why I have intimated this court.
You have to
And
explain
regarding-
to them, kindly you explain to them that amicus curiae is a friend of the court. It is neither of your nor of the other party. I am
I was appointed by the court. You
Madam,
withdraw the
I don't need your explanation. I am just submitting to the court. I don't need your explanation. What court,
It's very rude, Lordship.
what court will direct us will definitely comply, Lordship. Now, secondly, Lordship, we are ready to settle this case. Thirdly, Lordship, regarding this delay part, Lordship, I want some time to satisfy this honorable court with some favorable decisions in my case. Recently, more than 400 days has been in a MFA case. This delay has been condoned. Lordship,
No,
yes,
listen to my query.
Lordship.
Listen to my query carefully, then answer. The only point which has been raised by the amicus is that you have not explained a particular period. No explanation. So, had there been some explanation, it could have been accepted. You have not explained after lapse of 60 days.
67 days, Lordship.
No, after lapse of 60 days from the date of
Yes,
judgment,
yes, Lord.
which happened in the month of September, till you were informed in the month of October. That period you have not explained at all. That
But
is the only concern.
Lordship, we have honestly detailed everything. I have got instruction from my client, Lordship, that on 16th and 23, I was appointed in this case. But I was finally handed over the brief on 26th and 23, Lordship. Thereafter, there was some vacation. I was out of station, Lordship, in the meantime, Lordship. And I got this on 26th and 23. Finally, it was filed on 17/11/23.
Now, what your company was doing from
Lordship, there are some procedural delays also.
that you have not explained.
Lordship, I have explained.
The judgment was passed on 12/7/2023. The limitation expires on
In pair number 4,
12/9/2023. From 12/9/2023, where is the explanation?
in pair number 4 itself, Lordship, I have stated that the petitioner begs to state that the processing of papers from one office to another and from one table to another took some time, Lordship. But I could not specifically mention this exact dates, Lordship, because they were not supplied to me. So what date they have sent the file to the head office, what date they have received actually the file, on what date they have received the legal opinion from the senior counsel.
No, insurance company is dealing with lots of MSA appeals, MFA appeal. So you know that the period of limitation is 60 days.
60 days, Lordship.
So you have to at least mention, since the date of lapse of the period of limitation, what caused the delay. That is not mentioned.
That might be because, Lordship, I was not instructed specifically about these things. And what I have stated, Lordship.
Now, what is your
without any-
submission?
My submission legal appraisal should be given, Lordship, because there is not a substantial delay. It's only 67 days delay, Lordship, in this preferred. We are ready to settle. The main fact is that we are ready to settle this case. Until and unless the claimant comes, we are not able. In last occasion also, we tried to settle this case, but I could not contact this claimant. Lordship.
Settlement,
The parent of this
you
decision.
pay the awarded amount. That is the
We
settlement.
are ready, Lordship, but they have to come. If Madam Mazumdar able to.
Lordship, what is settling? I would like to know. If they are ready to pay there is no question.
Not ready to pay.
This delay or the MFA, Lordship, there is no question. Let them withdraw this IA and pay the compensation to because they are poor, they cannot even appear, Lordship.
That's why
It was the submission of the council himself. That's why Lordship appointed me. So this IA can be withdrawn and they can pay the amount to these people, Lordship. That is my humble submission.
Then, Lordship, give me some time. I will take the instruction. Accordingly, we will withdraw this case.
That is to be recorded then, Lordship, that he is submitting, that they will withdraw the
We are
IA.
ready to pay. Earlier also, we have stated that we are ready to pay.
Third, Mr. P.J. Burman, learned counsel for the applicant. Also, Miss R.D. Majumdar, learned amicus curiae, appointed by this court on, who was appointed by this court to assist this court on 22/5/2026. Learned counsel, learned amicus curiae, while making her submissions, has pointed out that the period of limitation for filing appeal against the impugned judgment is only 60 days, which lapsed on 11/9/2023. However, the applicant has not given any explanation for the period between 11/9/2023 to 16/10/2023.
17/11, when they filed the.
No, from 16/10 they have given some 16/10/2023. It is, she submits that it is only after 16/10/2023 till the filing of the appeal they have given certain explanation. On the other hand, learned counsel for the insurance company submits that he needs some time to take necessary instructions. He further submits that the insurance company is ready to settle the matter and ready to pay the awarded amount to the claimant and seeks some time for taking necessary instruction in this regard, so that if necessity arises, the insurance company may even also withdraw this interlocutory application. The prayer is allowed. Let this matter be listed
After 2 weeks, after vacation lodge.
5th of August.
Obliged, sir.
Listed.
Highly obliged.
Item 37.
With 37, my lord, also directed to GMC to file an affidavit. We didn't file on 22nd, my lord, but it's not on record. And the case is fixed on 28. It is taken up on 26, my lord, along with my affidavit.
What is this actually? What is the issue?
The issue is that your order has been vacated and allowed GMC to file his witness statement. That is the issue.
Again, that you are.
Yes, Your Lordship. Because the objections which were raised by us, Your Lordship, that were not examined and no observation was made by the Honorable Court below. As well as we raised the
Heard Mr. J. Chopra, learned counsel for the petitioner, also heard Mr. S. Bora, the learned counsel for respondents, who submits that though the respondents have filed their written objection against the present written objection on affidavit against the revision petition filed by the present petitioner, same is not placed on record. He therefore prays for issuing direction to the registry to placing the objection filed by the respondent with the record and listing this matter on 26th
July.
No, I don't think I'm wrong, my lord, one thing. I thought this coming up on 28 June. It's fixed on 28 July. So lordship later did it
Reopening.
after vacation.
17 July.
We are appearing on behalf of respondent 4, 5, and 6.
Also heard Mr. S. Dr. Leonard Senior Counsel, assisted by Mr. A. Bishwas, appearing for respondent number 4, 5, and 6. You have anything to say?
Next,
List accordingly on 17th.
Can it be on 16 or 18, apart from 7?
16th.
Item 38.
May I please, your lordship? Lordship, I have held this IA for allowing me to withdraw the deposited amount, 50% amount that has been deposited.
Any objection?
We have already deposited.
Heard Mr. U.G. Soikia. U.J. Soikia, learned counsel for the applicant. Also heard Mr. P.M. Talukdar, R. Busho, appearing for the opposite party insurance company. This interlocutory application has been filed by the applicant / claimant praying for allowing the present applicant to withdraw it is 50%,
50%.
allowing the applicant to withdraw the 50% of the awarded amount which has been deposited by the appellant insurance company before this court, before the registry of this court, in person to the order dated 11/2/2026, passed in IA civil number 350/2026, arising out of MAC number 45/2026. The learned counsel for the insurance company raises no objection against the prayer made by the applicant, hence same is allowed. The amount, 50% of the awarded amount, which has been deposited by the insurance company in pursuant to the directions of this court, shall be disbursed to the applicant by the registry after proper verification. This interlocutory application is accordingly disposed.
Much.
What has happened to main?
Registered already, my lord. Receive notice. MSC appeal 45 of the 26, my lord. We have reached.
How many all respondents have appeared?
The step has been taken.
Mr. PM Talukdar, learned counsel for the appellant, also heard Mr. U. J. Saikia, appearing for respondent number?
Respondent 1.
Respondent number 1. Oh, 1 and 2.
Two, three, my lord, there.
Driver.
Driver and owner.
2 and 3.
Who is the owner, my lord? State head.
The office note dated 25/2026 shows that the respondent number 2 has engaged a counsel by filing wakalatnama, whereas notice issued to respondent number 3 has been duly served. As such, the service of notice on all parties is complete. It also appears that records of the concerned MSC case has been received by the registry. Hence, this appeal is ready for hearing. Place this matter for hearing on 29 September.
Item 49.
May it please your lordship. Your lordship, as per office note dated 22/6/2026, we have issued notice on all the respondents. However, no AD card or answer notice has been served yet. Your lordship, at this stage, notices may be awaited.
Heard Miss R. Das, learned counsel for the applicant. On perusal of the office note dated 22/6/2026, it appears that service report in respect of notices issued to the respondents is awaited. The registry is directed to place the postal track consignment report before this court on the next date fixed. Let this matter be listed. 5th of August.
May I please? As per office note dated 22/6, service report is awaited in respect of all the respondents.
Heard Mr. A. Bhattacharya, learned counsel for the applicant. On perusal of the office note dated 22/6/2026, it appears that service report in respect of notices issued to the respondents is awaited. The registry is directed to place the postal track consignment report of notices issued to the respondents by speed post before this court on the next date fixed. List this matter again, 7th of August.
Obliged.
What's it, 22 days they're filing appeal. As per office note dated 19/6/2026, notice on respondent number 2 has returned that addressee was not found. This is National Insurance Company, Lordship. Lordship, we will take step by dusty on respondent number 2 on proper address.
2 is insurance company.
Other,
Okay. Heard Mr. S.K. Goswami, learned counsel for the applicant. On perusal of the office note dated 19/6/2026, it appears that notices issued to respondent number 2 has returned with an endorsement that endorsement within bracket left. The insurance company left the address.
office has been shifted because it is a rented house. We'll take a dusty service on respondent number proper service.
Learned counsel, as regards other respondents, the
Wait for
service report is awaited. Learned counsel for the applicant prays for allowing the applicant to take steps for issuance of service of notice on the respondent number 2 by dusty mode, as the respondent number 2 is an insurance company
In proper address.
at its proper address. The prayer is allowed. In the event the applicant is able to serve the notice on respondent number 2 by dusty mode, it shall file an affidavit in compliance thereto on the next date fixed. As regards other respondents, the registry is directed to place the postal track consignment reports of the notices issued to said respondents by speed post before this court on the next date fixed. Let this matter be listed 14th of August.
Obliged.
Some of the peculiar case, my lord, we were a defendant in a particular case, my lord, where there was an injunction order status quo, and when we objected that there is an injunction order violation, the plaintiff filed an application that these defendants are, though we are the main defendants, these are not main defendants, and they are required to be struck off from the suit. Now the Honorable Court passed the order striking us off. This order was of 18 of November 2025. But then, my lord, the order was not uploaded. Then subsequently, when we applied for a copy of the order, ultimately in January, a copy was given. So from January, my lord, technically there was no delay, but then technically, my lord, a 4 days delay have come in, my lord.
Okay.
Counting from 18/11/2025.
Heard Mr. B. Pathak, learned counsel for the applicant. This application under Section 5 of the Limitation Act has been preferred by the applicants, praying for condoning 4 days delay in filing the connected revision petition, whereby order dated 18/11/2025 passed by the Court of Learned Civil Judge Junior Division Rangia in title suit number 11/2012 has been impugned. Issue notice to the respondents. Since Ms. M. Kolita has appeared for respondent number
5B, 5C.
5A, 5B, 5C, and Mr. A. K. Bhattacharya. You are appearing for 5A? Okay. Then you can also appear for one state of Assam. No, Miss Kalita, you can also appear for respondent number 1. Oh no, 5A.
5A is the state.
Okay, 5A, 5B, 5C. No notice need to be issued to the said respondent. However, the petitioner is directed to furnish requisite numbers of copies of the interlocutory application to the Learned Government Council within 2 days from the date of this order. As regards other respondents are concerned, the petitioner shall take steps for issuance of notice to the said respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 12th of August. Yes.
Not the case main suit is fixed for hearing already on 17th of July, madam.
But how do you?
I cannot now participate in the main suit also because being the main defendant, I have been stuck off, my lord.
Then there will be no decree against you if you are not.
My lord. No, but then they have not amended the prayer. That is the interesting part in the civil division. The prayer is against me, my lord.
But without.
All the reliefs that are sought for are against me, but then I have been stuck off as a party
Without
respondent,
you
my lord.
being a party,
My lord.
how a relief can be granted against you?
That is also true, my lord. That is also true. That decree will be a nullity, my lord. But then it will lead to multiplicity of litigation. All I pray is that, my lord, can we have it on immediately on reopening, 13th or 15th, my lord.
14, 15.
My lord.
15th of July.
Deeply.
Item 43.
The they have filed for withdrawal lawsuit, but they are not here. And in the appeal,
You have any objection?
but with phone lawsuit. Because ours is on the DL issue.
Let them appear.
Yes, Lordship, that would be better.
None has appeared for the applicant on call. Miss R.D. Majumdar, Learned Counsel for the insurance company is present. Release this matter again. 31st July.
Lordship, in the appeal, Lordship will take up appeal as per office note dated.
Yes.
22/6/26, Lordship, LCR received, so yes, R1 file wakalat number for AD card for, Lordship, we had taken by speed post. So registry, why it is waiting for AD card, sir?
Okay. Heard Miss R.D. Majumdar, Learned Counsel for the appellant. The office note dated, though the name of Miss Meghali Bora is shown as the engaged counsel for respondent number 1, she was not found on call today. It also appears that the service report in respect of notices issued to other respondents are awaited. The registry is directed to place the postal track consignment report of notices issued to respondent number 2 and 3 by speed post before this court on the next date fixed. Let this matter be listed on 31st July.
Highly obliged.
May I please your lordship? Lordship, conducting counsel was requesting for passover for the day, lordship.
What is the matter?
They had to take some file to IS for substitution. I mean, substitution they had filed, but there was a delay. And Lordship on the last occasion has said that setting aside abatement and delay consolidation is also to be filed.
Heard Miss, what is her name?
Yes, Sheikh, on behalf of M.
Yes, Sheikh, appearing on behalf of MU Mahmood, learned counsel for the appellant, who prays for an adjournment for the day. Also, Mr. M.K. Chaudhary, learned counsel for this, all respondent except respondent number 8. The prayer is allowed. Let this matter be listed on 3rd of August.
Obliged, Lordship.
My lord.
May it please, Your
It was submitted I have not served with a copy of to the IA, they have filed. Under order 13 and rule 1 and 2, I just go through the office note. They have filed the application under order 13 rule 1 and 2. That copy has not served to upon me.
We will direct them to furnish.
Yes. When if your lordship goes through a merit of the case, this petition is not maintainable because this should maintain why this case is arising out of different cause of action. Why file
I am sorry, Rashid, but what can I do if my friend is so anxious to argue the matter?
Not arguing. I'm just telling what I have gone through that. Yeah, I have filed a case for against the injunction suit for defamation, and that injunction was granted. That to not to publish, and they have filed this FAO to vacate that in stay order, and they have filed it and they got a stay order vacated. Now they have filed a petition here in the order 13.1.2 that some Elisa.
I think so. I am qualified enough to assist the court.
Held on 5th.
Let him submit.
If I may.
I'll come.
That obviously is going to be held on 5th. That has to be stopped. That injunction they have won. How is this cause of action different? And here the parties are different. They have whatever party they have, not a party. They are what their prayer. The party they have.
Let them submit at this. You raise objection later on. I'll give you chance.
In fairness, since my friend, let me be very fair. We did not know that he would be appearing. Since he has appeared and has made a grievance that he has not served a copy, if your lordship so pleases, we can serve him a copy now, and his lordship can take up this matter too, so that he at least has some time to go through the petition.
10 minutes of this.
No, just serve
In that case, if
or otherwise don't make a grievance. Or otherwise don't make a grievance. We are saying that I'm being fair to him. Let him serve a copy.
You serve a copy, we'll take it tomorrow.
Day after tomorrow.
No, not day after tomorrow, lordship. Let it get 2 o'clock today, lordship, because there is some urgency. There is some urgency which I'll be able to demonstrate, lordship. If lordship can kindly accommodate us at 2 o'clock. At 2 o'clock, lordship will hear us. Just now he was telling me something different. Let us do it at 2 o'clock.
Let it be then tomorrow, my lord.
I would request at 2 o'clock.
Tomorrow at 2 o'clock.
Okay,
We'll
serve
2 o'clock.
Very well. I will.
Heard Mr. M. Goswami.
Very
Learned You are Mr. Goswami.
Yes, lordships.
Learned Senior Counsel assisted by Mr. R. Singha. Learned Counsel for the Where is the FAO? FAO has been admitted.
FA has been admitted. The order passed by the trial court has been stayed by this court.
Okay.
The whole case, if I may say in a nutshell, is they are misusing the whole system. They are misleading the judicial order on Facebook, Instagram. I'll point out, and they have now got a stay of their Leave India notice from the other bench filing a writ petition saying that he is not well, and on 5th he is organizing a tournament. Once lordships get a hang of the facts, lordship will understand how a foreigner is taking the Indian legal system to a right.
This order is in FAO. This application under Order 39 Rule 1 and 2 has been filed by the applicants in connection with connected first appeal against order number FAO number 35/2026. Mr. Mr. S. Mitra, appears for the sole respondent and submits that he has not been furnished with the copy of the present instant interlocutory application and prays for the same and requests that the matter may be taken up tomorrow so that he can go through the interlocutory application before he makes his submission. Learned Senior Counsel submits that the applicant would be furnishing the copy of the interlocutory application today itself, considering the submissions made by learned counsel for both sides and urgency shown in the case. Let this matter be listed tomorrow at 2 p.m.
I'm very good. Very good.
Let the name of Mr. S. Mitra be reflected in the cause list.
Wait, please, your lordship. Your lordship, this matter has already been admitted. It has wrongly been listed in the admission column.
Item number
7, your lordship. It should have been listed in the orders column. The service, the TCR has been received as per the office note dated 19/6/2026. Your lordship may kindly fix the matter for hearing.
heard Mr.
A. Deb.
A. Deb, learned counsel for the appellant, who submits that this is item number 7. This matter has already been admitted and it is ready for hearing. Hence, praise for listing this matter in appropriate column. Since the records of the trial court have been received, and since the Union of India is also represented by its counsel, let this matter be listed for hearing on 29 September.
Much obliged.
It's a review petition, lordship.
My lord, I have to point out one thing, my lord. While the continuation petition was allowed, they are directed to pay rupees 5,000 to the respondents. So we have not received any amount, my lord.
Lordship directed to file before the.
You have
before the-
deposited.
Yes, then only the review was numbered, Lordship. Your Lordship has already directed.
You
and
take it from registry. I will
Yes.
pass it. I
Right.
will
If they approach.
instruct the registry to.
Already there, Lordship. The instruction is already there in the
But we
order.
have not been intimated anything. That payment has been.
I'll make
My lord.
that reflection in today's order.
And in the review petition, my lord, we will file an objection petition.
Let them file.
Lordship.
Heard Miss R. Chaudhary, learned senior counsel assisted by Miss B. Hajurika, learned counsel for the review petitioner. Also heard Mr. A. Sigdar. This is item number A.R. Sigdar, learned counsel. You are appearing for how many?
Only one response.
Appearing for the sole respondent, who submits that though this review petition was filed with a delay and while condoning the delay, this court had directed the petitioner to pay a cost of rupees 5,000.
On 21/5/2026, delay was condoned.
However, same has not been paid. Delay condonation application, yes. Not been paid to the respondent. On the other hand, Ms. R. Chaudhary, learned senior counsel, submits that in pursuant to the direction of this court by its order dated
5/2026.
21/5/2026 passed in I number 393894/2025. The petitioners have deposited the cost of rupees 5,000 before the registry of this court, and thereafter only this review petition has been registered. The registry is directed to disburse the said amount to the respondents. To the respondent namely.
Lordship, that direction already in paragraph 21 of
It
the
is
order
there.
itself. They may approach the registry, then only the registry will disperse the.
Yes, the disburse the to the respondent in pursuant to the directions given by this court earlier. The respondent may approach before the registry for the same. Mr. A.R. Siddha, learned counsel for the respondent, submits praise for some time for filing a written objection against the review application filed by the petitioner. The prayer is allowed. Let this matter be listed. 10th of August.
Lordship, if they are filing a written objection, then Lordship may issue notice. No formal steps would be required as already they have received the copy. Then only.
Issue notice. However, since Mr. A.R. Sikdar has already appeared for this home respondent, no formal notice need to be issued. List accordingly on 10th of August.
If it is possible in the month of July, Lordship, already they are possessing the land, only I am fighting for
31st July.
obliged.
Court hearing under order 41, I am there.
Wait, please, Your Lordship. This is my substantial question of law, madam. Although this is a concurrent finding, my lord, but the first appellate court, in my humble submission, my lord, not at all applied its judicious mind and merely technically affirmed the judgment passed by the court below, my lord.
What is the error?
My lord, error, my lord, we are the defendant in the suit, my lord. The plaintiff case is simple, my lord. They have stated that, my lord, their forefathers have purchased this land by way of a sale deed in the year 1953, my lord. And 2014, my lord, suddenly they have come up with a case that, my lord, we have, and goes upon their, some of their portion of the land. And accordingly, they have filed this suit for seeking right and declaration and recovery of possession, my lord. Our defense was that, my lord, we are also co-pattadar, we are also staying by virtue of sale deeds, my lord. So with regard to the identity of land, my lord, there is some confusion, my lord. That has not at all been considered by the court below, my lord. Both the courts below only held that, my lord, since we have not disputed the sale deed, my lord, so possession was also decided in their favor, my lord. But for this last 60 years, my lord, they have not given a single documents to show that, my lord, they are in possession, my lord. Directly in the year 2014, my lord, they have come up with a case, my lord.
And on what basis trial court decreed this one?
Trial court simply said that, my lord, since we did not object to their sale deeds, my lord, and possession, my lord, only basis of their oral evidence, my lord, trial court decided that.
Any execution case has been filed?
Yes, my lord. Execution.
Heard Mr. P. Sundi, learned counsel for the appellant. This appeal under section 100 of the Code of Civil Procedure 1908 has been preferred by the appellant, impugning the judgment and decree dated 13/11/2025. There was a delay?
My lord?
Delay in filing this?
No, my lord.
Okay. 30, 13/11/2025 and 26/11/2025 respectively by the Court of London, Civil Judge Senior Division, Sonitpur, Tejpur, in title appeal number 20/2024, whereby the judgment and decree passed on 9/8/2024 by the Court of London, Civil Judge Junior Division number 1, Sonitpur, Tejpur, in title suit number 56/2014 was affirmed and the appeal was dismissed. After hearing learned counsel for
So it was
the appellant, also suit was
decreed in favor of the plaintiff, my lord.
appeal was dismissed.
Yes, appeal was dismissed, sorry.
After hearing learned counsel for the appellant, as well as after going through the materials available on record, following substantial question is formulated in this appeal. Whether both the courts below committed perversity in arriving at the conclusion that the land over which the present petition appellant has possession for more than 6 decades belongs to the plaintiff, and same has been encroached upon by the present appellant, and thereby declaring the suit as well as affirming the appeal. Stop. Read.
Look, any other substantial question of law at the time of the hearing?
Okay, okay. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 10th of August. Admit the appeal. The appeal is admitted.
I filed an application for seeking stay, my lord. Like,
In the IA heard so, Mr. P. Suli, this interlocutory application has been filed under Order 41, Rule 5 of this Code of Civil Procedure, praying for stay of execution of the impugned judgment and decree dated 13/1/11/2026 and 26/11/2026, passed by the Court of London Civil Judge Senior Division, Sonitpur, in title appeal number 20/2024. Learned counsel for the applicant submits that the aforesaid judgment has been impugned in the connected regular second appeal number 78/2026, which has already been admitted by this court. He further submits that substantial question of law has also been formulated in the said appeal, and notices are issued to the respondents. He also submits that in the meanwhile, respondents have already initiated a title execution. Case number?
The case number may not actually be followed, but the date is, take the case, I will just furnish the case.
Case number dash.
The case number.
Stop. Issue notice to the respondent. The applicant shall, similar to appeal, in the meanwhile, till next returnable date, further proceeding of the title execution case number so and so shall remain stayed. Listed.
Much obliged.
Please, Your Lordship. Yes. Lordship, in respect to item number 44, Lordship, I would pray before Lordship for an accommodation after the vacation, Lordship.
Lordship, as
Other
per the
parties.
respondent number 1. Lordship, the CRP is of the year 2017 arising out of landlord-tenant dispute. Lordship, a short date may be given if the matter is adjourned for days.
After the vacation,
Lordship, there is concurrent finding of both the learned as well as first appellate court. Lord.
On request of Mr. Z. Mukit. Z. Mukit.
Lordship W. Hawk,
W. Hawk.
on behalf of General.
Counsel for the petitioner, which has been conceded by the learned counsel for the respondent number 1. The prayer for adjournment is granted, and let this matter be listed. 29 September.
Can it be immediately after vacation, Lordship? Because it's 17 matter.
No. 29 September.
Obliged.
Delivery of order pertaining to idle bench, item 1.
For reasons mentioned in the order, the bail application, the prayer is dismissed. Prayer for grant of bail is rejected.
Obliged.
Number 1 pertaining to prohibitions.
Record. Yes, notice has been served or not?
My lord, I have been told that your lordship will be sitting likely from August 3 to 7.
You are appearing for?
For the applicant review.
The review petitioner?
Yes, my lord.
This IA is for what purpose?
Continuation, my lord.
Condonation of delay.
Yes. My lord, here the problem. After your lordship order, and that
We will fix this matter on first week of August. 4th of August. I'll be there in Kohima.
My lord.
It will be easier.
Yes,
much.
Yes, my lord.
So let us fix it on 1st of August, 4th of August.
My lord.
And Mr. Imti Longchar. I Imti Longchar. Learned counsel for the applicant. Also Mr. E. Tiba Foam, learned government counsel.
For respondent number 1 to 8.
For respondent number 1 to
8.
3. Anybody else?
9. My
Lordship,
lord.
I'm for respondent number 9.
Yes, what's your name?
And April.
I could not get it.
And April.
Henry Poro, appearing for respondent number
9.
9. Whether respondent would be filing any written objection?
No, Lordship.
Let this matter be listed on 4th of August again.
Much obliged.
Lordship.
Much obliged.
Before senior counsels argues on merit and the preliminary objection is started.
What preliminary?
Should may peruse an affidavit dated 17/6/26, additional affidavit.
Item number किमान?
It starts from page 160.
Yes. Yes, what is your objection?
Appended to that affidavit is an amended memo of appeal, which I understand is without the leave of the court, Your Lordship. Memo of appeal that has been annexed with an affidavit in additional affidavit, Your Lordship. Lordship, if this is permitted, Your Lordship, my understanding it will set a wrong precedent, Your Lordship. Amended memo of appeal without the leave that to annexed with an additional affidavit, Your Lordship.
Amended memo of appeal.
Lordship. As annexure X starts from page 162. Look what is pink color flag.
Pink color flag, Your Lordship, can you see?
Yes.
One of the facts of the case is this, my lord.
No, you address his
My lord.
objection.
My lord, this is not an additional ground, my lord. We have placed our grounding in page number 4 of our memorandum number 2. My lord, only there are some modification of the grounds. Only question number 1 I have put. And if your lordship not considered that memorandum, we have not, we have other grounds also. And your lordship kindly see, while your lordship is found that the question put in the pink flag, it is really a substantial question of law, then your lordship can put it. Otherwise, it is page number 4 of
Otherwise, in your memo of appeal, you have
page number 4.
Have you mentioned any substantial question of
Yes,
law?
yes.
You have otherwise mentioned.
Yes. Page number 4, your lordship can see.
Yes. Okay, what is the case?
Case is, my lord, I am the defendant number 3 in the suit. The suit was filed by one.
By filing this amended memo of appeal, what have you done?
I done only put one substantial question of law.
One additional substantial. Okay, okay.
That was if your
No
lordship-
other change.
No, no other.
Okay.
If your lordship found that is not the substantial question.
Then
of
we'll
law,
not formulate.
consider. And if your lordship found, yes, it is the substantial question of law.
Then we'll formulate. Okay.
My lord, the one Abdul Rashid filed a suit against the appellant and 2 others for declaration of right title interest over the scheduled land, and the defendant enclosed the scheduled land, declaration that the defendants have no right title interest of scheduled land, cancellation of sale deed, and rectification of record of rights. The case of the plaintiff is this, my lord. Their father
You are the defendant number 1.
3.
Defendant number 3. And against 2 others also suit was filed.
Yes.
Apart from you.
Yes, yes.
Okay.
Because 2 others and myself is different interest, my lord.
Okay.
Because I purchased a plot of land from them, 1 and 2.
Okay.
And my own ancestral land is there.
Yes.
Well, their case is this: one Sapauddin Sheikh, he was the owner of around 2 biga something of land, a pata number so and so. The late Sapauddin Sheikh gifted 3 kata 15 acres to her daughter, then 4 kata 15 acres to his son Abdul Rahman, and another 4 kata 5 acres to another son Abdul Rashid. Who is the plaintiff in the suit?
So to plaintiff 4 kata 5 lechas were gifted by his father.
Yes.
Okay.
My lord, I have given one, my lord, Khatian it is in the page 158 you also can see. At the beginning of the,
In the additional affidavit.
yes. Page 150. 150 where it starts.
Yes.
And you'll also kindly turn to page 158.
Yes.
158, it is a Khatian.
Yes.
It is a Khatian exhibited by the plaintiff. Here, my lord, your lordship see, Sapauddin Sheikh was the owner of 4 Katha, 50 acres of land. Habibur Ali, Nadir Ali, Aizuddin, Shahadat, and Bakhtar Ali. But the appellant is the son of Bakhtar Ali. Bakhtar Ali had 1 Katha, 5 acres of land. 7.
Yes.
1 Katha by Bakhtar Ali, the owner of 1 Katha, 5 acres of land, and Aizuddin Sheikh 2 Katha, 18.5 acres.
Yes.
It is in the serial number 5.
Yes.
And Aizuddin is the father of defendant number 1 and 2. And defendant number 1 and 2 sold the 2 Katha, 18.5 acres to the defendant number 3.
Okay.
Therefore, thereafter, Aizuddin sold. Thereafter, the defendant number 3, defendant number 3 became the owner of around 4 Katha, some lessons. 4 Katha, 3.5 acres.
Okay.
And moreover, in the same Khatian, we purchased the land. The Bakhtar, the father of the plaintiff, purchased the land. Father of the defendant number 3 purchased the land prior to the
Your father's name is
Bakhtar Ali.
Bakhtar Ali.
Yes. 7.
So your father was owner of 1
Katha,
Katha,
5
5
acres.
lechas.
And
And
Aizuddin
you purchased 2 Katha.
No, I purchased 2 Katha, 18.5 acres.
From Aizuddin.
From the heirs of Aizuddin.
From the heirs of Aizuddin.
Heirs of Aizuddin is the defendant number 1 and 2.
So your total land is?
Total land is 13, 3.5 acres and 4 Katha, 3.5 acres.
From what you have inherited from your father, as well as what you have purchased from the heirs of Aizuddin.
Yes.
Okay.
Therefore, I have the title over the plot of land. The plaintiff filed a suit that I encroached their land. Encroached their land and I raised construction. Therefore, they filed a suit for the declaration and cancellation of sale deed.
Sale deed of,
Sale
you
deed
sell it from Aizuddin's
son.
heir.
Aizuddin heir in favor of me.
Okay. So cancellation of sale deed in respect of 2 Kathas, 18.5 lechas land.
Yes.
Okay.
Because the trial court, in the plain, they have stated another thing, another story, that the Sapauddin Sheikh, while alive, the name of the appellant was mutated. The Sapauddin Sheikh filed a case before the circle officer. That was rejected and they went with it up to Board of Revenue. Board of Revenue also upheld the mutation of the appellant in respect of that land. And my title has been confirmed so far revenue part is concerned. Thereafter, my lord, there is a statement that he filed a case before the Board of Revenue and the plaintiff lost. If their title is lost and without praying for any declaration that the Board of Revenue's order is illegal, where my title is confirmed, can he file this civil suit without challenging that
No,
order?
Board of Revenue has not made any declaration on title.
Declaration of title, but mutation was
Mutation was upheld.
upheld. Mutation was upheld.
Yes.
Therefore, your lordship, therefore, kindly see my substantial question of law.
On what basis suit was decreed?
Suit was decreed on almost all the issues.
No, why your sale deed was cancelled?
My sale deed was
Sale deed of Aizuddin Sheikh, why it was cancelled?
my sale deed was cancelled because because
What was held by the court?
because their name was in the Kachapatta.
Whose name?
The heirs of Sapauddin. Heirs of Sapauddin, that is the plaintiff. Plaintiff number 1 and 2.
Okay.
And Benardi, another
And why decree for eviction was on what was the ground?
ground, Melody, I am illegally occupying their land.
What is your contention?
My contention is this. I inherited 1 kata 5 lakhs from my father, and I purchased 2 kata 18 lakhs from the heirs of IGP.
Why the trial court did not consider your?
That is the.
What was the reasoning?
That reasoning is there is no such reasoning, my lord. The trial court held that it is his right their right over the land is perfect because their name appeared in the sitar.
Whose? Plaintiff's?
Plaintiff's name. And the learned trial court failed to consider the mutation granted in my favor and the sale deed that was executed by the heirs of Aizuddin in my favor. And the whole sale deed is cancelled by the trial court without.
Sale deed was cancelled, giving what reasoning?
There is no reason.
There has to be some reasoning.
Without any reason. Only.
What substantial question of law you are suggesting?
My lord, 165 page you also can see. My first substantial question of law is this, my lord. The learned court below misconstrued the provision of Limitation Act 1963 in holding that the suit is governed by Article 65 and not by Article 59 without taking into consideration of Order 23, Rule 2 of the Code of Civil Procedure, in as much as limitation will run from the date of filing of the earlier suit as provided in the Article 58 of the Limitation Act.
What is this?
My lord, the plaintiff filed a suit against the defendants, against the appellants. That suit was, they withdraw that there is some formal defect. That prayer was allowed on the payment of cost of rupees 5,000. That they have deposited and they filed a subsequent suit. In the said suit also, they challenged my sale deed, the word I have made here. My sale deed was challenged. Therefore, that suit was the period of limitation. That suit was numbered as That suit was numbered as in the year 2006. That suit was numbered in the year 2006. In that suit also, they prayed for cancellation of the sale deed. Our contention before the court is this, my lord. In that view of the matter, the suit is governed under Article 58 of the Limitation Act.
What is 58?
It is 3 years from the earlier suit is 75 of 2006. To obtain another declaration, 3 years when the right to sue accrue.
Earlier suit was 75/2006.
Yes.
And subsequent suit was,
Subsequent suit was
the present suit is numbered as
11 of 2014 is old number.
11 of 2000.
2014 old. And new number is TS 131/21.
So your plea was the suit is barred by limitation.
Limitation. Because they have prayed for the cancellation of sale deed in the earlier suit. And cancellation of sale deed is 3 years. And the
But other relief for declaration was also declaration and eviction of.
no wait.
What court held that the limitation period is 12 years?
The trial court, both the courts held they are governed under Section 65, Article 65. 12 years.
12 years.
But it is not the case because 59 your lordship will kindly see to cancel or set aside any instrument or a decree or the rescission of contract 3 years when the facts entitling the plaintiff to have the instrument or decree cancelled or set aside or the contract.
Whether this plea was taken before first appellate court?
Yes.
This was taken. But
Ground number 7 in our memo of appeal in the lower appellate court.
Okay. What else is?
Against this was decided.
This is the main substantial question.
That is the substantial question of law and number 2 also. The learned court below erred in cancelling the registered sale deed number 1431 dated so and so of defendant number 3 appellant without taking into consideration that the alleged enforcement only being a part of the purchased land. Because my purchased land is 2 kata 18.5 acres and I am possessing the land. And I am my father also one of the pattadar of the said patta. And what area I have occupied under the said deed executed by the heirs of Aizuddin, that is to be surveyed first. And the area is to be measured and demarcated. Then the cancellation of sale deed will come and recovery of possession will come. Because without appointment of survey commissioner to measure and demarcate the alleged trespassing of the land, no decree can be passed.
No, the plaintiff's land is earmarked. Plaintiff has mentioned the area of his land in his schedule.
Yes.
The decree is granted
The decree
in
is
the
for cancellation of sale deed. The decree is for cancellation of sale deed, and in their plan they have stated we have encroached 2 kata 1 lesa of their land. Therefore, a survey commissioner has to be appointed. because I purchased the land 2 kata 18.5 acres. And
That sale deed was cancelled.
Whole cancel.
full sale deed was cancelled. And recovery of possession was decreed.
Yes.
And my lord,
Anything else?
my lord, the other grounds 2, 3, 4 are also the substantial question of law.
Yes, Mr.
My lord, so far the caveat is concerned, my lord, the caveator cannot oppose the admission of appeal. They can only oppose on the interim prayer. Because the 148, section 148A, it is clearly stated that any application in the suit or appeal, not the admission of appeal, not the presentation of appeal, the caveator has no right to oppose. They can oppose only on the interim applications. One 148A. So 148A, right to lodge a caveat when an application is expected to be made or has been made in a suit or proceeding instituted or about to instituted in a court, any person claiming any right to appear before the court on the hearing on such application may be lodged a caveat in respect thereof. Where a caveat has been lodged under subsection 1, a person to whom the caveat has been lodged, a hearing of the caveator, shall serve a copy of the caveat registered post acknowledgement and the application has been expected to be made or under subsection. Where the caveat has been lost and the application shall be filed.
No, your submission is caveator does not have right to be heard under
Only at the time of hearing of the interlocutory application. Injunction, attachment, all these petitions they can oppose, but they cannot oppose the admission of appeal because admission of appeal is between the court and the appellant. To that effect, I have a judgment.
Yes.
It is a paragraph number 22. It is a division bench judgment of the Calcutta High Court. Paragraph number 22. This court is of the view if the second appeal is presented before the High Court may have 3 stages. The first stage is before the stamp reporter. The stamp reporter has to find out if there is a defect in the appeal or whether or not the appeal is barred by limitation. The appellant technically admitted at this stage. If that hurdle is crossed, the appeal is a defect-free one. It is taken up by the court. At the time is a curable defect. The second stage is the satisfaction of the High Court that the substantial question of law is involved in the appeal. If such question exists, then the formulation of those questions by the High Court accepted the hearing. At these 2 stages, the respondent has no right of hearing. If the second appeal survives at these two stages, then the third stage begins and the respondent enters into the seat. The appellant comes for hearing. So the instant case, the initial stage of formulation and the substantial question of law by the High Court, the respondent has no right of being heard in this connection. Therefore, this is the law.
Statute also says, yes, Mr. Mukherjee. Statute says,
That-
Order 41, Rule 11 application, only appellant has to be heard.
Yes, the court has to be satisfied, but it is also no more res integra that the court will have to be satisfied whether there is a substantial question of law involved or not.
That is court will decide.
Well, the one that is suggested, Your Lordship, is squarely covered by issue number 5 that is decided by both the courts. Court will just look into it. It's regarding limitation. Issue number 5 has been beautifully dealt with by both the courts.
What has been decided? Issue number 5.
Page 122.
Page 123. Issue number 5. Whether the suit is barred by limitation.
What court has that?
Well, my contention is my ground for appeal is this, the limitation. His finding of the both the courts are absolutely irrelevant and wrong. And my lord, if your lordship see the
Wrong correctness, or if a court wrongly applies a provision of law, can that be a substantial question of law?
Yes.
If there is no perversity, suppose there is a perversity, only
wrong application of the provision is a why it is not the question of why. It is a question of
then every question will be substantial question.
no, every question cannot be substantial.
Then what would be the what is the
When the both the courts when the courts held the decision findings that is against the law and without fair interpretation of the provisions, they came to a wrong conclusion, then it will be a substantial question of law.
Then in every second appeal, the appellant will allege that the first appellate court has committed wrongly.
Not that case.
At this stage of admission, every appellant will say that court has to see that whether the question involved in this case is substantial question.
Yes, yes.
What is substantial question has been laid down by.
My lord, the questions of law and the substantial questions of law, there are two things. My lord, what I have stated in my grounds, that is the substantial question of law. That is not the question of law.
What is the difference?
Well, substantial when the interpretation of the section provisions of the law is wrongly interpreted or wrongly
Wrong.
or fail to
Wrong interpretation you will allege in every case. Every appellant will allege.
well, yeah, if you lots to see the judgment I have here, paragraph number 23 you also can see.
Okay. Heard Mr. A.C. Sharma, the learned senior counsel, assisted by Mr. G. Bhardwaj, learned counsel for the appellant. Also heard Mr. B.J. Mukherjee, the learned counsel for the cavator / how many respondents? All respondents. All respondents. This appeal under section 100 of the Code of Civil Procedure 1908 has been preferred by the appellant, impugning the judgment and decree dated 12/11/2025, passed in title appeal number 3/2023 by the Court of Learned Civil Judge Senior Division, Bongaigaon, whereby the judgment and decree passed by the trial court, that is the Court of Civil Judge Junior Division, North Salmara, Abhayapuri, in title suit number 131/2021. On 16/5/2023 has been affirmed and the appeal has been dismissed. Upon considering the materials on record, as well as after hearing the learned counsel for the appellant, this court is of considered opinion that this court formulates following substantial question of law in the instant regular second appeal dash. Whether both the courts below committed perversity in applying Section 60, Article 65 of the Limitation Act 1963 for considering the question as to whether the suit filed by the plaintiff was barred by limitation and whether the appropriate article to be applied in the while considering the said question was Article 59 and Article 58 also.
58.
And Article 58 of the Limitation Act 1963. Whether the trial court as well as First Appellate Court next also committed perversity in coming to the finding that the plaintiff is entitled to get a decree of eviction of the present appellants from the suit land without ascertaining the area of alleged encroachment by the present appellant by appointment of a survey commissioner. These two will be enough. Issue notice to the respondents.
Respondents already
Since Mr. B.J. Mukherjee, learned counsel for the respondent, has already entered his appearance, no formal notice need to be issued to the respondent. You have been served with the copy. Stop.
Notice eligible and level.
Let the records of the First Appellate Court and the trial court be requisitioned. Let this matter be listed again after receipt of the aforesaid records on 10th of August.
Well, they have in the meantime started the execution case. that IA Civil 1648.
You have to say anything.
If it may be stated in the returnable date, Your Lordship, I may file a objection because in the IE, probably I will have a right to respond.
Heard. Mr. A.C. Sharma, Learned Senior Counsel, assisted by Mr. G. Bhardwaj, Learned Counsel for the applicant. Also, Mr. B.J. Mukherjee, Learned Counsel for the respondents. This interlocutory application under Order 41, Rule 5 of the Code of Civil Procedure 1908 has been filed by the applicant in connection with RSA number 56/2026, praying for stay of execution of the impugned judgment and decree during the pendency of the connected regular second appeal. Learned Counsel for the Learned Counsel for the respondents prays for some time for filing written objection against the same. Prayer is allowed. Let this matter be listed 10th of August till returnable date. However, since the connected regular second appeal has already been admitted and substantial question of law has been have also been formulated therein till next returnable date, the execution of
Malad, I got the title execution case number. I got it from the E-Court.
What is the
Lordship can
number?
put the number.
Execution proceeding of title execution case number 163/2.
Title execution case number 25 of 26.
25 of 2026, pending before the Court of Learned Civil Judge Junior Division, Abhayapuri, shall remain stayed till next returnable date. List accordingly.
I live.
Item 11. May please, Your Lordship. Lordship, this is against the judgment and judgment and decree dated 9/7/2025, passed in civil just by the Civil Judge Senior Division, Morigaon, Assam, in connection with title appeal number 12/2023. The judgment is at page.
Where is the substantial question of law?
Lordship, that I have given in the first substantive. In the first, it is annexed in the separate sheet in the first page. Substantial question of law.
It has to be there in the memo of appeal.
Lordship, we have given it in a separate sheet. The grounds we have taken, but these are given in a separate sheet.
Yes, what is your case?
Lordship, here the dispute relates to a plot of land. And the respondents, they were claiming that by way of inheritance. There was what has been stated, in the written statement filed therein, we raised the objection against the whether the respondent number 2 is a legal heir of the Sabu Sheikh through whom they are claiming. And for that was the one of the question to be decided by that is Mohibur Rahman, whether he is the son of Sabu Sheikh or not. That was the question raised there. Because he is not the son of, according to us, he is not the son of Sabu Sheikh. Rather, he, after the death of Sabu Sheikh, his mother, this Khatemon Nessa, she solemnized her second marriage, and out of that marital wedlock, he has born. And thereafter,
On what basis trial court has decreed?
Lordship, it is decreed on the basis of the revenue entries, because there was a revenue entry after the death of the Sabu Sheikh. There was a revenue entry in the year 1983, wherein the name of the Mohibur Rahman was entered in the revenue records. On the basis of that, the trial court has came to the conclusion that this Mohibur Rahman, he is one of the son of the progeny. In order to reboot that contention, we have given certain voter list. Those were not considered. Now the first question of law that we have posed is whether the first appellate court has erred in drawing presumption under section 114 of Indian Evidence Act that the principal respondent of the being to be the legal heirs of late Sabu Sheikh relying solely upon the mutation entries produced by the principal respondents and rejecting the usually admissible evidence, that is the voter list, produced by the appellant in oblique defendants, creating a discrepancy of the age, doubt about the paternity of the plaintiff number 2. Because these revenue entries repeatedly the court.
How this can be substantial question?
Lordship, because these revenue entries, the entire case is decided on the basis of a revenue entry. And these revenue entries are for the purpose of fiscal purpose only. So these, there cannot be, these revenue entries cannot be relied upon to determine solely the paternity of the respondent number 2, that is the respondent number 2. So that is one of the questions,
whether there was any other evidence, counter evidence.
Counter evidence was voter list we have placed.
The courts, by applying the principles of preponderance of probability, relied upon revenue entries to come to the finding that because in revenue entries also Mohibul has been shown as son of Sabu Sheikh.
Sabu Sheikh. But these we have produced another document that as per the affidavit, these entries were his age at the time of the entry was made. At the time of death of Sabu Sheikh, he was not there because he has declared his age and that in the affidavit filed before the court in the written statement. So as per that, he was not born in the year 1983.
When he was born.
Lordship.
When was he born?
He was born in the year 1985. That we have taken in the ground.
When Sabu Sheikh died?
Sabu Sheikh died in the year 1983.
So have you adduced any evidence to show this death of Sabu Sheikh as well as birth of Mohibul?
Because we have produced those voter lists.
Voter list is not proof of age.
Other evidences.
In voter list,
we have relied upon the declaration he has made on oath. We have relied upon that also.
Both the courts, the trial court decreed the suit, appellate court upheld it.
And
moreover, whether execution case is pending.
Yes, Lordship. Now execution case is pending, and there is another discrepancies. That is regarding the schedule. The schedule A land they are claiming, and they initially they stated that there was a mistake in the schedule. Thereafter, the court has allowed an amended plaint was filed. Even in that plaint also the schedule B, which they are claiming to be a part of the schedule A land, the DAG number has been shown to be different. This patta number has been shown to be different. In the schedule A land, they are claiming that schedule B land is a part of the schedule A land. And as per the schedule given in the amended plaint that I have annexed, and schedule starts from page 34, it says the plot of land measuring 1 bigha 2 kotha 15 lesser land of annual patta number 92 of village Korunabari, Moja Iman Sajansas. The schedule B land, they are saying that land measuring 2 kotha 11 lessers out of 1 bigha 2 kotha 15 lesser covered by DAG number 327, annual patta number 2. So suit land is not identified. And moreover, we raised, there was this schedule A land.
Suit land is not identifiable. That cannot be a substantial question.
No, Lordship. Moreover, this schedule, there was no perfect or imperfect partition of the schedule A land. That was a specific stand taken by written statement. And that no question was to form whether there was partition of the schedule A and B land or not. Because they are saying, or they're claiming that the schedule A land, the schedule B land is a part of the schedule A land. That can be identified only once there is a perfect or imperfect partition. That we are saying that our stand was
A land has been jointly owned
No, they claim that, and they claim right title and India prior portion, they have claimed
Entire schedule A land.
Schedule A land. And the learned first appellate court has modified that to the extent that they are also the owners. But neither the trial court nor the first appellate court has decided whether there is partition or of the Schedule A land in order to identify the Schedule B land. That was not found, but decree was given that the Schedule B in favor of the plaintiff regarding this this Schedule B land. And without partition, perfect or imperfect, there cannot be Schedule B land. That also we have raised. The question whether the trial court at the first appellate has committed error both in facts and law by failing to frame issue in the title suit number 39/2017 to the effect that whether there was any perfect or imperfect partition of the suit land.
No, this cannot be a substantial question.
And the evidentiary of the voter list were totally negated by the first appellate court.
That also cannot be a substantial question of law.
And another question, they have stated that whether the court below has erred in law or drawing presumption under section 114 of illustration G of the Indian Evidence Act that non-examination of the father of the appellants, because that is the principal defendant number 4 in the title suit, and Uncle Kazimuddin, performer defendant number 8 in the title suit, as witnesses is unfavorable and adverse to the appellant's case, ignoring the limitations provided under the subsection 114 of the para 1.
That is also, what is the substantial question of law? Substantial question of law is a question of law which is not decided.
Lordship,
This may be.
Sheikh died in the year 1983. And this second son, his Mohibur Rahman, his son, who claims to be his son, he was born in the year 1985.
That may be.
That is the main, that is,
Yes.
we have taken the ground.
You have anything to say?
Ships, it's a concurrent finding, and the learned court below already decided the facts and was the interim judgment order. So there is no any question raised regarding substantial question of law. Actually, there is no substantial question of law in this case, because facts already clearly decided.
Who was the plaintiff?
Plaintiff,
There are three plaintiffs.
three plaintiffs here.
Muhammad Khataman Nisa, Muhammad Mohibur Rahman, and Muhammad Nazia Khatun. They claimed, and this Muhammad Mujibur Rahman, in the plaint, he has mentioned his age as 29 years.
As regards
which was filed on 29/6/2017.
As regards other two appellants.
Other two
plaintiffs.
admitted that they are the legal heirs of Sabusi, daughter and the wife.
Then as regards them, you have no objection.
As regards them regarding this legal heirs, we do not have any objection. That was not raised there. Actually, this Schedule A property, they have given some other property in lieu of Schedule A property to them. And one daughter was there who was not made party initially of the Sabu Sheikh's daughter was there. So she was given this property.
Lordship.
Sabu Sheikh married three.
These three plaintiffs are claiming to be legal heirs of Sabu Sheikh.
And out of them, this Muhammad Mohibur, there was another person. Another daughter
you
of Sabu
answer
Sheikh.
to my query. The present plaintiffs, three plaintiffs.
Yes.
All of them are claiming to be legal heirs of
Sabu Sheikh.
Sabu Sheikh. And you are raising objection only with regard to one of them.
Regarding these two. means, sorry, one of them, that is Muhammad Mohibur Rahman.
Mohibur,
Yes,
who is plaintiff number?
Lordship.
Plaintiff number
Plaintiff number 2.
2. As regards the other two plaintiffs, you don't have any objection.
This plaintiff number 1, she got married with another person after the death of Sabu Sheikh. So we do not have any objection because she is one of the legal heirs. Admittedly, she initially got married with Sabu Sheikh. But our another objection was that they cannot claim this property as because in lieu of this property, another property was given to her and wherein she is residing now. That was one of the contention in the written statement.
Mohibul was born on
Lordship, he on plaint was filed on 29/6/2017. Plaint was filed on 29/6/2017. Original plaint was filed. In that plaint, he has declared his age as 29 years. And from the said entry, it can be inferred that his year of birth was 1988.
1988.
That we have stated in our grounds.
When he died?
Lordship.
Sabu Sheikh died.
Sabu Sheikh died in the year 1983. And PW1, that is the principal.
Mr. S.N. Tamuli, the learned counsel for the appellant. Also heard Mr. What is your name?
A.L. Mandal.
A.N. Mandal. Learned counsel. You are appearing for all the respondents.
1 to 3, principal respondent.
Respondent number 1, 2, and 3. This appeal under section 100 of the Code of Civil Procedure 1908 has been filed by the appellants. Impugning these appellants are legal heirs.
Lordship, some are legal heirs, some are performer respondents. Oh, sorry, appellants are legal heirs.
Impugning the judgment and decree dated 9/7/2025 passed by the Court of London, Civil Justice Senior Division, Morigao, in title appeal number 12/2023, whereby the judgment and decree dated 14/11/2023 passed by the Court of London, Civil Justice Junior Division number 2, Morigao, in title suit number 39/2017 was affirmed and the appeal was dismissed. After hearing after considering the materials available on records and after considering the submissions of learned counsel for the appellant, following substantial question of law is formulated in this appeal. Whether the first appellate court as well as the trial court have committed perversity in treating the plaintiff number 2 to be a legal heir of late Sabu Sheikh, ignoring the clear evidence on record which suggests that the late Sabu Sheikh expired in the year 1983, whereas the plaintiff number 2. Now, what is the name of plaintiff number 2?
Mohibur Rahman, Mohammad Mohibur Rahman.
Muhammad Mohibur Rahman was born in the year 1988. As such, he 1988 stop. Issue notice to the respondents. Since Mr. A.R. Mandal, A.L. Mandal has appeared for respondent number. You are appearing for only principal respondents.
Yes.
1, 2, and 3. No formal notice need to be issued to the said respondents. You have received memo of appeal.
No. Copy not
The appellant is directed to furnish requisite number of copies of memo of appeal along with the annexures to the learned counsel for the appellant, learned counsel for the respondent number 1, 2, and 3. As regards other respondents are concerned, the appellant shall take steps for issuance of notice upon respondents by speed post as well as by usual mode, Putul, usual mode within 7 days from the date of this order, returnable within 7 days from the day, returnable on 10th of August, list accordingly. You have anything to say in IA?
Yes, I'm going to file objection. Objection petition also not.
Okay. Whether execution case has already been filed?
Yes, Lordship, the title execution number 18/25, pending before the Civil Judge Junior Division number
Heard
2.
Mr. S.N. Tamuli, learned counsel for the applicant. Also heard Mr. A.L. Mandal, learned counsel for respondent number 1, 2, and 3. This interlocutory application has been filed by the applicants in connection with the connected RSA number 83/2026. Under Order 41, Rule 5 of the Code of Civil Procedure 1908, praying for stay of execution of the impugned judgment and decree dated 9/7/2025 passed by the Court of Learned Civil Judge Senior Division, Morigao, in title appeal number 12/2023. During the pendency of the connected regular second appeal number 83/2025. Learned counsel for the applicant has submitted that the applicants have impugned the aforesaid judgment and decree in the connected regular second appeal, and same has been admitted by this court. He further submits that substantial question of law has also been formulated by this court and notices have been issued to respondents. He also submits that in the meanwhile, the respondents have already initiated an execution proceeding, that is title execution case number 18/2025, and hence prays for putting a halt on the execution of the impugned judgment and decree during the pendency of the connected regular second appeal. On the other hand, Mr. A.L. Mandal prays for some time for filing written objection against the prayer of the petitioner, of the applicants. Prayer is allowed. Let this matter be listed 10th of August. In the meanwhile, considering the fact that the connected appeal has already been admitted till next returnable date, the proceedings of title execution case number 18/2025 shall remain stayed. List accordingly.
Item 12. May it please your lordship. This is a judgment, decree of reversal, lordship. The suit land is an annual patta land. Plaintiff's case is that he is the annual patta land holder. And he says that in the year 2019, the defendant dispossessed him from the suit land. The defendant number 2, he filed a written statement as well as a counterclaim. His plea is adverse possession. His father is possessing the suit land since 1958.
You are the defendant.
I am the defendant number 2.
Okay.
Then, lordship, the trial court dismissed the suit and decreed the counterclaim. And
On the basis of adverse possession.
yes, on the basis of it, we have proved our the ingredients of adverse possession on the basis of evidence. Suit was dismissed and the counterclaim was decreed. Then that is reversed by the appellate court. But interestingly, lordship, kindly see at page 13 of my memo of appeal, these are the suggested questions of law. That first question is whether decree of the learned trial court passed in the counterclaim can be set aside by the learned appellate court in absence of any appeal preferred by the plaintiff against the said decree of the counterclaim.
Okay.
Now, if lordship sees that at page 28 is the counterclaim, lordship. Page 28.
Yes.
So far as first substantial question of law is concerned, here lordship will see from para 27, the counterclaim is there, and lordship kindly note at page 31, para 31. Page 31, para 31 of the counterclaim. This counterclaim is valued at 4 lakhs and at Veloram court fee 5,206.60 plus that fixed court fee of declaration 22 has been paid. Now, lordship kindly see the memo of appeal at page 68.
Yes.
If your lordship see, even lordship the appellant, all the appellants have not filed, all the plaintiff have not filed the appeal. Only 4 has filed this appeal. And if lordship kindly see it at page 69, they have challenged the decree of the suit. If your lordship sees the valuation part,
Dismissal of this.
dismissal of the suit. If your lordship see the valuation, value of the suit as accepted by the trial court is rupees 4,50,000 for the purpose of the court fee, and court fee of rupees 6,725 is paid thereon as per the provisions of law. So this plaint was valued at rupees 4,50,000, and they have paid that 607 court fee, and the appeal is also valued at this thing, lordship. Whereas I have shown from the, because your lordship, law is that the plaint and the counterclaim 2 separate proceeding. If there is a common judgment, then also 2 separate appeal has to be filed. And
is it the law?
Yes, I'll show it, lordship. With the permission of the court, single appeal can be filed. But in that case, with the leave of the court fee has to pay for suit as well as counterclaim. So that is the first thing that. Now, lordship see, counterclaim has been decreed. There is no challenge, and it is set aside by the trial court, appellate court. Sorry. Now, in this regard, lordship, similar question was before this honorable court at the time of this framing of substantial question of
But
law.
this is a settled law. That cannot be done.
Yes, lordship, I've also got some judgment from the Kerala High Court and also.
And
lordship,
then how it remains substantial? How it becomes substantial?
it affects the rights of the parties, lordship. Without challenging, lordship, kindly see that 3F at page 6 of that order. F, lordship, at page 6. That lordship, the RSN, RSA 194/2018. May I read you, lordship?
Yes.
The contention of the learned counsel for the appellate that the respondents had challenged the trial court judgment by filing an appeal. As such, first appeal by the respondents must be construed to have been filed against the trial court judgment as a whole, and it would be inclusive the challenge to the counterclaim, that is the contention. This court finds it preposterous that challenge against the dismissal of the suit would include dismissal of the counterclaim, which is admittedly against the interest of the respondents. Therefore, there is no way that this court can accept that by challenging the judgment and decree, the dismissal of the counterclaim was also challenged by the respondent. In the opinion of this court, though counterclaim and the suit are decided together as per provisions of Order 8, Rule 6A2, it is provided that counterclaim has an effect of a cross suit, and it is for the said reason that the provisions of the Order 8, Rule 6C permits the exclusion of counterclaim. Moreover, the provision of Order 8, Rule 6D provides that if the suit of the plaintiff is stayed, discontinued or dismissed, the counterclaim would proceed. Therefore, in essence, there are two separate proceedings which are tried and decided by the common judgment. Therefore, if any party is aggrieved, both by decree in the suit and the decree in the counterclaim, it is provided that two separate appeal be filed unless the court accepts common appeal for both in the suit as well as in the counterclaim, and therefore two sets of court fee are required to be paid for challenging the judgment in the suit and counterclaim, even if there is a single judgment. Under the circumstances, the submission made by the learned counsel for the appeal and that is challenge to the dismissal of the suit amount to challenge to the dismissal of the counterclaim is not sustainable and thus rejected. Now here, Lordship, our title and position has been confirmed by the trial court. It was not challenged in this appeal by way of separate appeal. Even they have not paid the court fee. It is apparent from the face of the appeal memo itself.
Okay. Any other point?
Yes, Lordship. The second one is also vital, Lordship. That at page 13, whether the decision of the learned appellate court holding that the suit of the plaintiff is not barred by the law of limitation is contrary to Section 27 and Article 65 of the Limitation Act in the fact situation of the case and the purpose for ignoring the vital evidence on record. So whatever evidence was there regarding the adverse possession, that was ignored by the appellate court. He is holding that the suit is maintainable, and Lordship, the Lordship maintainable and disposition. He had confirmed that disposition in the year 2019. So there is a perversity, Lordship.
Mr. What is your name?
And another Lordship, J. Deka, Lordship.
J. Deka, learned counsel for the appellant. This regular second appeal has been filed by the appellant, Shri Jadul Bora, impugning the judgment and decree dated 29/1/2026, passed in the title appeal number 28/2024 by the Court of Learned Civil Judge, Senior Division, Lakhimpur at North Lakhimpur, whereby the judgment of the trial court that is the Court of Learned Civil Judge, Junior Division, Lakhimpur, in the title suit number 40/2020, passed on 13/9/2024, was reversed, and the trial court's judgment in respect of the title suit as well as counterclaim was set aside. And reversed by the First Appellate Court. Learned counsel for the appellant submits that the present appellant was the defendant number 2 in the title suit number 40/2020 before the trial court. And in addition to filing a written statement, he had also filed a counterclaim. And the trial court has decreed the counterclaim and dismissed the suit of the plaintiff. However, he submits that the First Appellate Court, without there being any separate appeal filed by the plaintiff against decreeing of the counterclaim, reverse the judgment in the counterclaim by the trial court, which, according to learned counsel for the appellant, amounts to perversity. So, after considering the submissions made by learned counsel for the appellant, and after going through the materials available on record, following substantial questions of law are formulated in this regular second appeal. Number 1, whether the First Appellate Court committed perversity in reversing the judgment of the trial court in the counterclaim without there being any separate appeal against the judgment passed in the counterclaim by the plaintiff side. Number 2, whether the First Appellate Court committed perversity in holding that the plaintiff suit was not barred by limitation under Article 65 of the Limitation Act 1963. Issue notice to the respondents.
Lordship, 4 also important, Lordship, because out of 7, only 4 has filed the appeal.
Non-joinder cannot be a substantial question.
No, what I'm saying, Lordship, it is an annual patta land. Relief is granted, right title interest of the suit land. It is an annual patta, admitted annual patta land. And Lordship, out of 7, Lordship, only 4 has filed the appeal. So whatever the decree in the counter came, it remains operative against the other 3. Because all the appellant got relief of this suit, but they have not challenged that counterclaim part, and they have not filed the this appeal also, even in the representative capacity.
Whether the First Appellate Court, number 3, whether the First Appellate Court committed perversity in reversing the judgment of the trial court in the suit as well as in the counterclaim without there being any appeal from 3 out of 7 of the plaintiffs who were affected by the judgment of the trial court, as the appeal was preferred only by 4 of the affected plaintiffs. So, issue notice to the respondent. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 12th of August. This appeal is admitted. Let the records of the trial court as well as first appellate court be called for. Registry to may take steps for requisitioning the records. Any execution case has been filed?
That exact number is not known to us, but we have filed the stay application.
We'll issue notice.
But
Let them file an execution case. Unless execution case is.
That impugn decree
Decree
execution of
cannot
impugn
be stayed. Execution has to be stayed. Unless
Lordship, if the appeal is admitted, Lordship.
yes.
Because
Suppose
section 41 section 5 says that filing of appeal cannot be a ground for stay
Yes.
of the decree.
Stay of the
That is why
execution.
we file stay of the execution. Order
But
for,
where is execution case?
no execution case, Lordship, that exact number is not there, Lordship, but the execution.
We'll issue
40
notice. If they file
Lordship,
any.
just one moment, Lordship. This section 5 says, an appeal shall not operate as a stay of the proceeding under a decree or order appeal for except so far as the appellate court may order, nor shall execution of a decree be stayed, nor shall it be stayed by the reasons only on the appeal having been preferred from the decree, but appellate court may sufficient cause order stay of execution of such decree.
Yes. We will stay the execution provided execution case is filed.
Now, Lordship, what happens? Sometime, Lordship, since if they files within this two year, directly writ will be issued, Lordship. And if, because eviction is there, Lordship, if without serving notice that writ is issued and they evict us, then it will be a multiplicity of proceeding.
Issue heard so and so. Heard Mr. J. Deka, learned counsel for the applicant. Issue notice to the respondents. Steps similar to appealogenically say till next returnable day. The execution of the impugned judgment and decree shall remain stayed.
I'm deeply obliged, Lordship. Yeah, please, my lord.
Yes.
My lord, substantial question of law is at page 8, ma'am.
What is the case?
Lord, appellant before lordship is defendant number 1 in the suit, my lord. This is a fight between the brothers, my lord. What the case of the plaintiff is that, my lord, he has taken one soft room.
You are the plaintiff or defendant?
I am defendant number 1 in the suit, my lord.
D1. Yes. What is
My lord, the case of the plaintiff is that, my lord, he has taken one shop on rent from Tinsukia Municipal Board, my lord, and he is running that shop. In the year 2008, he came to Gauhati. When he returned back, he found that his shop was divided into 3 parts, my lord, and he was dispossessed from the civil B and C, my lord. Then he has filed the suit claiming, my lord, declaration of possessory rights as well as for recovery of possession of the suit land, my lord. The case of the defendant number 1 is that, my lord, the suit premises was purchased by the father of the appellant as well as defendant number 1 and 2 from one Ram Sukla Rai, my lord, and thereafter, my lord, he was running the shop. In the year 1983, the appellant married to some married to intercaste marriage. That's why he was ousted from the house, my lord,
and he started to recite separately. However, in 96, my lord, when our father is old age, he has taken back, and then he has divided the soap into 3 parts, my lord, giving to 3 brothers, my lord. And that's why these all the 3 brothers are running the shops, my lord. That is the case of the defendant. The trial court has
Why the suit was decreed by the trial court?
my lord, the trial court has come to a finding that the municipal board, my lord, who is the owner of the suit land, my lord, as per the record of the municipal board, the suit premises is in the name of the appellant, my lord. And
Appellant or the plaintiff?
Oh, sorry,
Plaintiff.
plaintiff, my lord, and therefore he is the owner of the suit land, and the disposition part, my lord, the court says, my lord, that
Plaintiff have purchased or he is
on rent, my lord.
on rent?
Rent.
Lease?
Not a lease, my lord, it is rent.
Rent.
Rent, my lord. There is no agreement, nothing is there, my lord.
Okay.
So the
Owner is the municipal, Tinsukia Municipal Board.
owner is the Tinsukia Municipal Board.
Okay. Thereafter what?
Well, the court has come to the finding that since that all the municipal board, as per the record of the municipal board, the plaintiff is the owner, and therefore he is entitled to possess the suit land. And with regard to disposition, my lord, although there is no proper evidence, but the court has found that since he is the owner, he is entitled to recover the suit land. Against that appeal preferred, appeal also dismissed, my lord.
Where is the court wrong?
My lord, my submission is that, my lord, first thing is, my lord, if, my lord, while during the pendency of the suit, the plaintiff has filed one petition for calling the evidence from the Tinsukia, calling a witness from the Tinsukia Municipal Board, my lord. That petition was rejected. Against that, they have preferred this honorable court. This honorable court, okay, you call the witness, but without any documents. That witness appeared. He has exhibited, my lord, exhibit 5 to 12. No. Exhibit 5 to 12, which shows with regard to ownership of the shop, my lord. And that, my lord, by relying on that documents, both the courts below come to a finding that he is the owner of the suit land, my lord. That is my first substance.
How he can be the owner? It is on rent only.
On rent, my lord. He has the possessory right of over the suit land.
And what is your case? How your father come into picture?
My lord, my father has come from purchased the suit land from one Ram Shukla Rai, my lord. In the
But
end,
suit land is, the suit premises has been lent on rent to the plaintiff by the Tinsukia Municipal Board.
yes, that is the case of the plaintiff.
How you have countered that?
My lord, the case of the defendant number 1 is that my father has purchased, my lord. It is not that the municipal board.
How you have, what evidence you have produced?
My lord, evidence, my lord, one kacha sale deed was produced, which was from the father and, my lord, the Ram Shukla Rai.
Who is Ram Shukla Rai?
Well, he was possessing the, my lord, suit land, my lord, at that time. My lord.
He is also not the owner.
He, my lord, the ownership, my lord, the Tinsukia Municipal Board is not.
That is not
in
in
a party, my lord, and that issue is not framed, my lord.
But that is not in dispute.
That is, my lord, not in dispute, my lord.
Then you don't have a case.
My lord, my submission is that, my lord, the Tinsukia Municipal Board is not a party, my lord. And, my lord, the documents on which the ownership was established, the court has come to the finding that the plaintiff case is established. All these documents are, the court cannot look into in view of the order passed by this honorable court, my lord. If lordship may kindly see.
Where is the order?
My lord, the order passed by this honorable court is at, my lord, page 121. Relevant will be page 122, my lord. May I read, my lord?
Yes.
This revision is directed against the order dated 19/6/2006, passed by the learned Municip number 1, Tinsukia, entitled suit number so and so, whereby and whereunder the prayer made in the petition number so and so has been rejected. I have heard so and so, learned counsel for the petition so and so. It appears from the petition number so and so that the present petitioner, who is the plaintiff in the aforesaid suit, has prayed for issuance of summons to listed official witness, namely the official of Tinsukia Municipal Board as PW3. In the said petition, no prayer, however, has been made to issue summons to PW3 to bring any document from its record. The learned Munsif, in view of above ought to have allowed the prayer for issuance of summons to PW3 for recording evidence without, however, directing it to produce any document from the record. In view of the above, the revision petition is disposed of, directing the learned Munsif to issue summons to the official witness of Tinsukia Municipal Board for recording his evidence. However, without any direction for production of any documents, there being no prayer in that regard, the impugn order dated so-and-so states modified, the revision petition is accordingly disposed of. Then Lordship may come to page 69, my lord. Page 69.
Yes.
My lord, this is the 11% of the trial court judgment. Lordship may kindly, the third line from the bottom, my lord. PW3, may I read, ma'am?
Yes.
PW3, he is the official witness of the Tinsukia Municipal Board, my lord. In support of his deposition, has exhibited document marked as Exhibit 6, the demand register, Exhibit 7, the computerized demand register, Exhibit 8 and 9 being agreement renewal receipt, Exhibit 10 and 11 rent receipts in the name of plaintiff in respect of Schedule A, Exhibit 12 is demand notice issued in the name of plaintiff in respect of suit premise demanding outstanding rent. Although PW1 deposed that there was no agreement of tenancy or paper of allotment in his name by the Tinsukia Municipal Board, but it is recorded and admitted fact that the Schedule A is recorded in the name of the plaintiff. So all these documents are produced by the PW3, who is the official witness, and this honorable court says that he may not be allowed to exhibit any documents.
That was not said.
The court says that the
Only
to call the witness, but
without any
document.
direction.
So all
But suppose he brings and exhibits, is there any bar?
my lord, my submission is
Whether have you raised this plea before the appellate
my
court?
lord, I have the ground is taken in the appeal memo, my lord. But
Where is that ground?
my lord, may I come to my lord, page number. My lord, 105, my lord. Ground number 33, page 105. Ground number 33.
Whether this was addressed.
No, my lord, not addressed. Even a review was filed for that, but the court has says that, my lord, that it is not within the scope of review, my lord.
How it becomes a substantial question?
My submission is that, my lord, with regard to ownership and ownership issue, my lord, the court has come to a finding mainly relying on these documents, my lord.
Okay. Yes, Mr. Gogoi.
My
You
lord,
don't have a right to be heard.
No, my lord, he do not have any right, my lord.
Just, I will just assist the court, not, not a, I will
Because,
assist
my lord,
the
there is
assistant
a
court.
judgment which says that, my lord, he do not have.
Earlier now, senior counsel has stated it, so he is now repeating it. I'm
Well, I
just-
have the judgment,
No,
my lord.
but that is.
My lord, I have a judgment, my lord.
I think I have to submit for your.
Is there any bar for the court to hear?
If lordship wishes, then lordship may.
Order 41 Rule 11 says after hearing learned counsel for the appellant. So order has to be passed after hearing learned counsel for the appellant. But if court feels, I think there may not be any bar. Yes, what?
He has said about exhibit 4 to 12.
5 to 10.
5 to 12. 5 is the summon, 6 is the manual register, 7 is the computerized register. And this 8, 9, 10, 11, 12 is our document. Is our document. Exhibit in the evidence, not the official witnesses call. And when
8, 9.
8, 9, 10, 11, 12, and 1 to 4, all are exhibited by the plaintiff.
Okay.
And secondly, when it was the documents were,
Show me from where are you saying?
I have filed one additional affidavit. It is page 161. The cross-examination of the PW3. 161 in the affidavit. Evidence and cross-examination. Page 161. You also got it? File 29/4/26. File by respondent number 1.
Yes.
I married. I appeared before this court on receipt of summons. I have been advised by Salmon Insurance Board to adduce evidence in this case. Exit 5 is the authority letter. Exit 5(1) is the signature of the Salmon Municipal Board, along with authority letter. I have got 2 numbers of documents. Only 1 manual demand register and 1 computerized demand register. I am present working as LD at Municipal Board and serving since 1994. Exhibit 6, the manual demand register, in which name of Vijananda Bhattakur, plaintiff is appearing against shop. And no number SSA1 is standing in the name of plaintiff. SSA1 is also written as SS82A1 SS, or SS stands for Sandehat and 80 stands for Assam type. And denote for block. Shop number SSA1 indicate that it is situated at Block A at Sunday Hall, and SM is Assam type. Exhibit 7 is a computerized demand register from the period of 31/3/2012 to 1/9/2023. As far as Section 7, Vijananda Bhattakur is a tenant of Municipal Board and is paying rent to the Municipal Board.
As per, read that line again.
As per Exhibit 6 and 7, Vijananda Bhattakur.
As per
6 and 7.
Exhibit 6 and 7, which are your document?
They are brought by Municipal Board.
That is his question, that cannot be relied.
You will see the below part. Exhibit 1 to Exhibit 4 are issued by our office. Exhibit 8 and 9 are agreement renewal receipt. Exhibit 10 and 11 are rent receipt in the name of plaintiff and in respect of Schedule A premises. Exhibit 12 is demand notice issued by TMB to the plaintiff in respect of suit rent, demanding outstanding rent. As our record, plaintiff is still paying rent regularly and bona fide tenant in respect of suit rent. Name of defendants, namely Abhinanda Bhattakur, Hirana Bhattakur, Sabuyan Dham, and Palasan are nowhere appearing in available municipal records. I cannot say who is in possession of suit land caused by defendant. When Municipal Board first allowed any shop to any person, an agreement is executed between municipality and that person concerned. I cannot say whether there was any agreement between TMB and plaintiff in respect of premises, as all records are available. Although TMB does not allow to run any letter shop by any subtenant by name at a time tenant subject to their shop to their brothers, relatives, non-person. We don't have a record prior to the 1991. And so they say admission on by the defendant number 1, page 166. Says, I am the person who is a tenant.
No, Mr. Gupta, your contention is that the trial court relied on Exhibit 5 to Exhibit 12.
Yes.
But out of 5 to 12, 8, 9, 11, 10, 11, and 12 are the plaintiff's document.
Exhibited by PW3.
There is no bar in exhibition. He did not brought the.
My lord, he has brought because he is the official witness. He do not have any possession over that documents, my lord. He brings from the office. He is the official witness, my lord. Because, my lord, the plaintiff exhibits, if lordship may come to page 131, my lord. He has exhibited only 4 documents, my lord. Page 131, my lord. Page 131.
Okay, this question is to be decided.
Because, my lord, page 131 for a moment, my lord, only 4 documents. my lord.
Founder, when the usual exhibit, he has to raise objection. It was not raised at the time of clause.
No,
Para 20,
we-
20 and 23. And
we-
admittedly, by the respondent, sorry,
we will admit the appeal. We will decide this question.
the plaintiff is around 74 years. For last so many years, 15, 20 years, they were occupying the premises. And you'll also may see one clause, one line, page 160, page 166, one line.
Page
66, one line, only one line.
where is 166?
It's in my affidavit. If it is a fact, their access suit schedules of house and payment of rent in respect of suit to Principal Municipal Board by plaintiff is also admitted. It is
Whose deposition is
the defendant one.
the appellant's?
Yes, in the cross. They have admitted, and the exhibit A which they have adduced is in the name. The Kacha, the agreement is in the name of the plaintiff, not in the name of defendants. The exhibit A, the findings of the appellate court. I can read. The Kacha, exhibit A is in the name of the plaintiff. The learned court below has said that the defendants have failed to prove any documents to claim of their premises, premises. No, not a single document. They are the tenants of the finding of the schedule A, exhibit A is here they have stated that is in the name of the plaintiff. Their document. It is by the appellate court. They have admitted in their cross. My shop, the municipal board has proved it. They are occupying forcefully. Now I'm around 24, 75. For last so many years, they were occupying it. All record says this, it is my shop. I'm taking one complaint. Now still we are paying rent. And it was proved by all the witnesses, PW1, 3, 2, 3, and even their admission in their cross. And the documents which have exhibit A.
Who has exhibited exhibit 8, 9,
Defendant 1.
No.
8?
Exhibited is plaintiff.
Plaintiff.
Plaintiff. No. Exhibit, actually, exhibit A.
No, exhibit 8.
I'm the plaintiff is exhibit.
What is exhibit 8?
Exhibit 8 is the agreement renewal receipt.
Exhibit 9?
Exhibit 9 is the agreement renewal receipt, and exhibit 10 is the rent receipt. Exhibit 11 is the rent receipt. Exhibit 12 is the demand notice by the municipal board to pay rent to me by me.
Who has produced these documents?
I have exhibited.
PW Lordship, page 131. For a moment, 131.
That type of prosecution, I have exhibited the document.
Page 1.
I can exhibit as well order 1304.
Page 131. The evidence of the PW1.
This one?
131. He has exhibited only 4 documents.
These rent receipts are mine at the time of.
No, but the official witness have produced.
Yes.
No. Official witness has produced only 3, 2, exhibit 6 and 7. These are not produced by official witness. These are exhibited, shown to the official witness and exhibited. They have not brought these documents.
On what basis you are saying that they have?
Page 131, my lord. If it
No,
is-
131.
This is the
He might not have exhibited it himself,
Yes, my lord, he has not.
but
exhibited.
his documents may be exhibited by some other witnesses.
But my question is only that, my
The
lord,
prohibition was only not to bring the documents. You have not taken steps. He has not taken steps for issuance of notice to official witness for bringing documents also. Therefore, this court said that only person will come without bringing any documents. But suppose when he comes, the plaintiff produces his documents, which he has earlier annexed along with the plain or has given in the list of documents. Then whether such documents, is there any bar in?
the proposition that says that lordship is absolutely right, but lordship may kindly see page 131.
Yes.
The plaintiff has exhibited only 4 documents, my lord.
Yes, he might have exhibited only four.
And all the documents are brought by the PW3, who is the official witness, my lord.
But he's saying that he.
No, my lord may kindly see page 130, his evidence, my lord. Whatever the
No,
document.
on what basis you are saying that he brought those?
My lord, even the PW3 evidence, my lord. PW3 evidence.
He cannot brought any document because notice was not.
No, my lord, he has produced the documents. If lordship may kindly come to page PW3, my lord.
I brought only two number documents. They've said it in the chief. Page
My lord,
161.
page 161, lordship may
I
kindly
brought number
come, my lord.
documents.
What he exhibits, my lord. Lordship may kindly page 162.
$162. Yes.
My lord, first lordship may kindly see exhibit 6 is manual demand register.
No, he is only exhibiting whether any question was put to him during cross-examination that who brought these documents. Whether when there is specific bar by the order of this court that no document can be brought by the. How this court will know who brought those documents?
My lord, my submission is that, my lord, this exhibits what I know, my lord, subject to correction, my lord. When the witness comes, mainly the official witness and all, they bring the documents and then, my lord, the exhibits are marked there, my lord. So
No.
here, in this case, my lord, the plaintiff has annexed, my lord, enclosed only 4 documents, my lord. That is exhibit 1 to 4.
Okay.
That is from the evidence of PW1.
But the prohibition on the plaintiff side by this court in its earlier judgment was that summons will be issued only to person, not to direct him to bring any document. Now you have to show that he brought those documents. There is nothing to show that who brought those documents. It is only he exhibited those documents.
Yes,
those documents may be in possession of the plaintiff beforehand also.
My lord,
how will we know?
My lord, if in the possession of the plaintiff, then he ought to have exhibited, my lord.
He may not exhibit it. It
Even-
is the choice of the plaintiff that by which witness he intends to get it exhibited.
That the PW3 is not, my lord, the plaintiff, although he is a plaintiff, but this is an official witness, my lord.
But he is plaintiff's witness.
Yes, plaintiff witness, but he is an official witness. He has come from the office of the Tinsukia Municipal Board, my lord. He is not that a private individual. He will say whatever is on the record on what the court asks, my lord, or what the document he exhibits, my lord. Above the record, beyond the record, he cannot go.
No, but in this regard, was there any cross-examination to the said witness?
Cross, that is not, no question is put in that regard.
Then you cannot take this plea now. Otherwise, there will be no end to litigation.
But
at any moment, you will raise any question.
But my submission is that, my lord, when this honorable court specifically says in the order that the witness is allowed, but no witness is, that saved witness will not bring any document. And he brings the document and he exhibits it.
No, very.
Because my lord, plaintiff exhibited only 4 documents, my lord. Because in his evidence, he has said only 1 to 4.
No, there is no bar in bringing documents. Bar was directing him to bring documents.
Yes, my lord, official witness will not bring any document without any, my lord, summons issued to that respect, my lord. Because he is a official witness, my lord.
So where was that summons?
Someone I do not have, my lord, what.
So how this court will know?
My lord, that is the question I am
How
raising.
this court will know that
My
there
lord,
was a violation of this court's
my
order?
lord, that is the question I am raising, my lord. For that, my lord, record
No,
will be
but
required, my lord.
that question cannot be raised at this stage. You have to show something from trial court records or appellate court records that in spite of the bar or prohibition, they issued summons directing him to produce documents, and in pursuant to that he appeared, and therefore it is in violation of court's order. But now there is only assumption and presumption. At this second appellate stage, this court is not inclined.
That someone I do not have, my lord. My lord, then the second substantial question at law with regard to perversity, my lord, since I do not have the summons, and my lord, already execution case is going on, my lord, 29 is fixed for, my lord, issuance of writ, my lord. So
No, unless execution has to go.
no, my lord, I'm not saying, my lord, then lordship may kindly see, my lord, second substantial question of law, my lord. That, my lord, with regard to perversity, my lord.
What is the perversity?
My lord, the issue number, my lord, 6 and 7, my lord, that is at page 70, my lord.
Yes.
My lord, issue number 6 is whether the plaintiff has been in past physical possession of the suit premises since 1974 until dispossessed. And number 7, whether the defendant number 1 and 2 have dispossessed the plaintiff from the suit premises illegally. My lord, here, my lord, what happened, my lord? The case of the defendant is that, my lord, father has purchased the suit land. And my lord, 83, when he has entered into marriage, intercaste marriage, my lord, he was ousted by the father, my lord. And then, my lord, father was running the shop. In 96, he was, when he comes back, then the shop was divided into 3 parts. So there is no dispossession, and he was not in possession of the suit land, my lord. But the court has come to a finding that since the municipal board records are in his favor, and therefore he is in possession of the suit land, my lord.
No, as regards possession, where is the finding?
My lord,
Dispossession.
may I read then, my lord, this page 71, my lord.
Yes.
Both issues being connected with each other, this court deemed it proper to discuss both issues jointly to avoid repetition of facts. PW1 had deposed that after taking the soap SHA1, he has been in possession of the same and he found himself dispossessed from the same in the year 2008 when he found Schedule A was divided into Schedule B and C being possessed by defendant number 3 and 4 respectively. PW1 deposed that at the time of taking the suit premise, there was grocery shop. Defendant side plea is that after marriage of plaintiff in the year 1983, he left the company of Muktinath Borthakur and shop of her soup premises was run by defendant number 1, Abhayanand Borthakur along with Muktinath Borthakur. And in the year 1996, their father divided the shop room bearing number SHA1 and SHA2, hand over the shop number SH2 to the plaintiff and SHA1 further divided into 2 parts. Eastern part is handed over to Hridayanand and western part is handed over to Abhayanand, which is the main plea of defendant side. But during cross-examination, PW1 has firmly denied suggestion that his father was running the grocery shop at that time. PW3, although has deposed that he cannot say who is in possession of suit premises, but it is also deposed that rent in respect of suit premises rent are paid up to date and plaintiff is still paying the rent regularly being bona fide tenant. PW3 also substantiated that defendants named Abhayanand Borthakur, Hridayanand Borthakur, Sammiran Dam, Palasmani Hajarika nowhere appearing in available municipal records. On the other hand, PW2 has firmly substantiated the claim of PW1 that in the year 2008, plaintiff was dispossessed from the suit premises. PW1 and PW2, although deposed that after marriage, plaintiff has started living separately, but that merely does not prove that plaintiff was in possession of suit premise. During the cross-examination, PW1 although deposed that he did not lodge any FIR against defendant number 1 and 2 for breaking the lock of this shop house, and also cannot say about articles which were in shop, and also did not file any legal notice against the defendants. But mere non-filing of FIR or issuance of notice does not demolish the plaintiff's case when it admittedly defendant number 3 and 4 are tenant of Schedule B and C respectively under defendant number 1 and 2 other than mere suggestions being denied by PW1. Defendant side could not bring any material contradictions, mere suggestion without supporting material are not going to help defendant side. As per Evidence Act, one who claims a fact, the burden lies on him. So here in this suit, the burden lies on the defendant side that Muktinath Gaur divided his shop SHA1 between defendant number 1 and 2, but during evidence, DW1 has clearly deposed that no documentary or otherwise material are produced to substantiate the aforesaid division of suit premises by their father. In absence of proof of any division of suit property by father of plaintiff and defendant number 1 and 2, in absence of any tenancy under plaintiff, the possession of defendant number 3 and 4 could not be seem to be unauthorized. Thus, under above factual and evidentiary position, it is found that issue number 6 and 7 are decided in affirmative and held in favor of plaintiff. My lord, may kindly see the cross-examination of plaintiff, my lord. That is at page 133. This is the cross-examination of plaintiff, my lord. I am 59 years old. In the year 1974, I was 17 years old. My lord, the suit premises was taken on rent in 1974, my lord. At that time, he was 17 years old, my lord. We were 4 brothers, white so-and-so, so-and-so. I have also 4 sisters. My father's name is so-and-so, who expired in 99, but I cannot recall the date and month. My unmarried sister so-and-so in the year 2000. Then, my lord, I married in the year 1983. My wife is now called as Gitali Borthakur and earlier called as Gitali Thakuria. My marriage was intercaste marriage in the year 1983, and after my marriage, I left my father's house and started living at Parvatia, Tinsukia. I took the suit house from Tinsukia Municipal Board as a tenant. There was no agreement of tenancy or paper of allotment in my name by the Tinsukia Municipal Board. The suit house is numbered as SHA1. At the time of inception of tenancy, there was only one room at that time. In the year 1974, there was shop of grocery item in the suit house. Then Lordship may skip all this, then Lordship may kindly come to page 134. Next page, my lord.
Yes.
Fifth paragraph, my lord. Page 134. I went to Gauhati. Lordship got it. I went to Gauhati.
Yes.
I went to Gauhati in the first week of the month of 2008 and returned back on 16/11/2008. On my return, I noticed that the defendant number 1 and 2, by way of breaking the lock of the door of shop number SHA1 and divided the same into 2 parts, and person are sitting as tenant in each part. It is not a fact that the defendant number 1 and 2 never break the lock on 16/11/2008. I did not lodge any FIR against the defendant number 1 and 2 for breaking the lock of the shop which noticed by me on 16/11/2008. I cannot say about the articles which were in the shop. I filed this suit in the year 2011, which is after 3 years from the year 2008. I also did not send any legal notice to the defendant. So, my lord, he is in possession. He is not able to prove that, my lord.
Oh.
My lord, he wants to say that when he went to Gauhati in the year 2008, and when he come back, he found that the soap is divided into 3 parts. In his cross, he admitted that 83 he married intercaste. Then there is dispute, my lord. So, and after, my lord, the alleged dispossession, no FIR, nothing is lodged, my lord.
Maybe because you are brothers.
My lord, brothers, my lord, but he has, he waited for 3 years, my lord. 2008, he was dispossessed. 2011 suit was filed, my lord.
But it is within the period of limitation.
No, that is there. I'm not raising the period of limitation, my lord. The preponderance of probability, my lord. That what
The
I'm saying.
court consider these factors.
The court has considered, but my submission is that, my lord,
It cannot be regarded as perverse. For perversity, there is no evidence. Court may arrive at a wrong finding. This court may go into reach a different finding, but that is not allowed in second appeal. Second appeal, unless you can show substantial question of law. Anything else?
These are my question of law. I leave it to your lordship.
Heard Mr. A.K. Gupta, learned counsel for the appellant. Also heard Mr. S.R. Gogoi, the learned counsel for the respondents. This appeal under section 100 of the Code of Civil Procedure 1908 has been preferred by the appellant Sri Abhayananda Bhattakur, impugning the judgment and the decree dated 19/12/2025 and 20/12/2025 respectively, in passed by the Court of London Civil Justice Senior Division Tinsukia in title appeal number 10/2024, whereby the judgment and decree, judgment dated 29/6/2024 and decree dated 5/7/2024 by the Court of London Civil Justice Junior Division number 1 Tinsukia in title suit number 21/2011 was affirmed, and the appeal filed by the present appellant was dismissed. The facts relevant for consideration of the instant. What is your name? Vijayanand?
My name is Abhayanand.
Abhayanand.
Defendant number 1.
Facts relevant for consideration of this appeal, in brief, are that the present respondent number 1, namely
Vijayanand
Bhattakur, had filed a title suit before the Court of London, Munsif number 2, Tinsukia, praying for the relief of declaration of possessory title, right and interest of the plaintiff over the suit premises as described in Schedule A to the plain. It was further stated therein in the plain that Schedule A premises includes the premises described in Schedule B and C below. B and C of the plain. The plaintiff also sought relief of recovery of possession of the suit premises by evicting the defendant. You are defendant number 3.
I'm defendant number 1.
Defendant number 2 has expired.
Defendant is there from. The suit was contested by the present appellant by filing joint written statement along with defendant number 2, wherein it was claimed by the present appellant that the suit premises was purchased by their father Muktinath Bhattakur from one Ramdin Shukla in the year 1974, and thereafter the suit premises was divided into 2 parts by the father of the defendants and were given to defendant number 1, that is the present appellant, as well as defendant number 2. Stop. On the basis of the pleadings of the parties, the trial court had framed. Where are the issues?
Page 60, madam.
Framed following issues. Court issues from page 60 and 61. Oh my God, how many issues?
Total 12 issues.
Court issues from page 60 and 61. Stop. In support of their case, the plaintiff in support of his case, the plaintiff examined 3 witnesses. These 3 includes official witness also.
Yes, PWP is the official witness.
3
One is the plaintiff, 2 is the
3 witnesses and exhibited 12 documents as exhibit 1 to exhibit 12. Whereas the defendant side deduced the evidence of 3 witnesses and exhibited some documents which were marked as exhibit A to exhibit I. Ultimately, the trial court decided the issues in favor of the plaintiff and decreed the suit by its judgment dated 29/6/2024, directing the recovery of khas possession of the Schedule A property and delivery of same to the plaintiff. Being aggrieved by the judgment of the trial court, the present appellant preferred an appeal before the Court of Learned Civil Judge Senior Division, Tinsukia. The said appeal was registered as title appeal number 10/2024. Stop. The appeal was contested by the appellants, by the plaintiffs. However, by judgment dated
19/12/2025.
19/12/2024, 25, the First Appellate Court dismissed the appeal and affirmed the judgment of the trial court. The said judgment of the First Appellate Court has been impugned in this appeal. Mr. A.K. Gupta, the learned counsel for the appellant, has submitted that the trial court has committed perversity in coming to the finding that the plaintiff is entitled to possessory rights and decree of eviction against the present appellant, mainly on the basis of Exhibit 5 to Exhibit 12, which were exhibited by the official witness, that is PW3. He submits that though this court, though a coordinate bench of this court, by its order dated
8/11/2013,
8/11/2013, passed in CRP number
247/2013,
247/2013, has modified the summons, modified the order of the learned trial court, modified the order of the trial court of issuing notice to PW3 for directing clarifying that though PW3 may be summoned for recording his evidence, however, he may not be directed to produce any document from the record. the learned counsel for the appellant submits that the appellant, that in spite of the clear prohibition by this court, by the said order, the PW3 brought the official documents which were later on exhibited as Exhibit 8, 9, 10, 11, and 12. He submits that it is clear from the evidence of PW1, who is the plaintiff of the case, that he exhibited only 4 documents, that is Exhibit 1 to Exhibit 4. And as such, the documents exhibited by the official witness are as such, it appears that the document, as such, he submits that the documents exhibited by the official witness, that is PW3, were brought by the said witness in violation of the direction of this court passed in CRP number 247
247 of 2013.
247/2013. Hence, the trial court ought not to have relied upon the said exhibits, and by relying upon the same, it has committed perversity. Further, learned counsel for the appellant, next para, learned counsel for the appellant, Mr. A.K. Gupta, has also submitted that the trial court also committed perversity in holding that the petitioner was in possession of the suit premises and suit premises stop. It also committed perversity. He submits that it also committed perversity by relying on the testimony of PW1 to the effect that when PW1 came to Gauhati in the year 2008, and after going back, he found that the lock of the suit premises were broken, was break opened by the respondent. He submits that during cross-examination, PW1 has deposed that no FIR was lodged against the breaking of the lock of the suit premises. Further, he submits that the trial court also did not consider that it was not natural on the part of plaintiff to wait for 3 years for filing the suit after being dispossessed from the suit premises. Hence, the conclusion arrived at by the trial court regarding possession of the suit premises in favor of the plaintiff and dispossession thereof by the respondent was perverse. As such, he submits that the substantial question of law formulated by the a substantial question of law suggested by the appellant in his memo of appeal may be formulated and this appeal may be admitted. Though Mr. S.R. Gogoi has appeared, the learned counsel for the appellant has appeared for the both. How many respondents are there?
Plenty. Respondent, this one number.
Respondent number one, that is the plaintiff. However, since for considering as to whether there is any, since in a hearing under Order 41 Rule 11 of the Code of Civil Procedure, only appellant's side is to be heard while deciding the question as to whether there is any substantial question of law involved in this case at the time of admission of the appeal. Hence, this court, after considering this courts will only take into consideration the submissions of learned counsel for the appellant as well as materials available on record to come to the finding as to whether any substantial question of law is involved in this case or not. Stop. ... I will dictate the order in chamber, but appeal is not admitted. No substantial question of law is found. Wait for the detailed judgment.
Yes. Obliged.
In chamber में अभिषेक ये साथ साथ ले लेना. Yes.
May it please your lordship.
Item number
51.
Yes.
Here, my lord, the substantial question of law is at page 8. The fact is that the respondent herein, a file was suit against me. There was a mortgage deed in the year 2002. In that mortgage deed, 8 bighas of land was put in the mortgage. There was a condition that within 3 years, if he could not repay that amount, then he will sell that suit land to the present appellant, who was the defendant in that suit. But after 2002 till 2017, he waited, and in 2017 he instituted a suit before the Court Learned Civil Judge Junior Division number 1 in Morigao for declaration of right, title and interest and recovery of khas possession as well as permanent injunction. And that suit was decreed in favor of the
Who
plaintiff.
mortgaged the land?
That plaintiff mortgaged it
With you?
to me, my lord.
Okay.
So that suit was decreed in favor of the plaintiff. Then, my lord,
He repaid the mortgage.
No, my lord, he did not repay. So then I preferred appeal, and admittedly, my lord, appeal was preferred with a delay of 258 days.
Okay.
And there's an application under Section 5 of Limitation Act or Confirmation of
Delay
Debt.
was not condoned.
Delay was not condoned. I had specific explanation, my lord. It is lordship will get it very peculiar situation.
What was the ground for delay?
ground for delay was that prior to delivery of the judgment and decree in the suit, I was severely ill and I was under treatment and lower back pain, some
No, what
neurological.
was the claim of the plaintiff? Whether he claim was that he repaid that mortgage
No,
amount?
he wanted to repay, but that particular clause, what was there in the mortgage deed,
For
that if
foreclosure.
foreclosure, and our counterclaim was for foreclosure. That was not considered. And my lord, that appeal 258 days delay, lordship will get that order at page 74 of my memo of appeal. It starts from page 78, my lord.
Okay, what was your ground?
My ground is that, my lord, this delay, lordship, kindly have a look at page 76.
No, you tell me what
That
was.
is, my lord, if learned first appellate court did not consider the medical certificate which was issued by the senior health and medical officer of Morigao Civil Hospital, wherein it is specifically mentioned that from 22/1/2025, I have been suffering from peripheral neuropathy since 22/1/2025, and I was advised for rest, my lord.
Where is the impugn order?
Impugn order, lordship will get it at page, it starts from page 73. Page 73, the relevant portion from page 76, my lord. Page 76, married. Seen the advice slip issued by STHG Civil Hospital, Morigao, in the name of Ramchandra Soikia, dated 30/10/2025. It is mentioned therein that Ramchandra Soikia is suffering from low back pain with peripheral neuropathy since 22/1/2025, and the judgment and decree in the suit was of 24/1/2025. Prior to that, and this certificate was of 30/10/2025. Till then, I was under his treatment and I was suffering. And since then, he has been under his conservative treatment and advised to take rest with regular medical checkup. It is seen that other than this document, no other medical document is furnished by the petitioner. As per the medical report, the petitioner had to take regular medical checkups, but petitioner, for reasons best known to him, failed to submit any such medical checkup prescription to substantiate his plea. Further, the medical document says that petitioner was taking treatment since 22/1/2025.
What is peripheral neuropathy?
Peripheral neuropathy, what I have understood, my lord, that due to some neurological problem, entire body is suffered the pain. I am not 100% correct, my lord, because I have collected the knowledge from third party.
No, is it a disease which enables
Yes,
a
my lord,
person
as
from
I-
performing day-to-day function?
Yes, my lord, as I am told. And he was bedridden. I have talked with him. And
No, there is no such pleading that you were bedridden. The pleading is that you were suffering from peripheral low back pain and peripheral
neuropathy. So peripheral neuropathy, what I went through, I've got that for this disease, a person may not be able to travel. That I have got, but I'm not sure. It's medical terminology.
But unless you are yourself not sure,
But
how will you convince the court?
This, no, the substantial question of law, what
Court considered this disease not to be sufficient
no,
cause.
court did not consider this. Court taken into account that except this medical certificate, no medical document was produced. That is the findings of the learned court below. But my lord, what section 119 illustration E of the BSA, earlier 114
No, suppose even
Evidence Act.
even if the court takes into consideration this document, whether is it sufficient to
My lord,
condone the delay?
this certificate was issued on 30/10/2025.
No.
And from 22nd of January
The
2025.
sufficient cause under section 5 of the
Yes,
Limitation Act.
sufficient cause. So what is there? Blood, the senior health and medical officer of civil hospital has,
In whose possession land is presently?
I am in
You are-
position. I am in position.
How much is the land?
8 bighas of land, my lord. Total
Yeah.
10 bighas. 2 bighas subsequently, 2 bighas were again put under mortgage, but there was no document. Written document is
How
not
much
there.
was the mortgage money?
1,05,000 in 2002. That he has admitted. 1,05,000 he has admitted, my lord. So now, my lord, what Learned First Appellate Court did not consider the provisions of Section 119 illustration E, earlier 114 E of the Evidence Act, which says, my lord, judicial and official works are presumed to be genuine. When
No, suppose even if it is assumed to be genuine, the question will arise as to whether the grounds shown by you was a sufficient ground.
that is, my lord, what I would like to submit, my lord. Lordship, may kindly have a look at this. Certificate was issued on 30/10/2025.
Abhishek. Heard, Mr. What is your name?
K.M. Haloy.
KL
K.M. Haloy.
KM Haloy, learned counsel for the appellant. Also, no, this appeal under section 100 of the Code of Civil Procedure 1908 has been preferred by the appellant Shri Ramcharan Saikya alias Ramchandra Saikya, impugning the order dated 2/6/2026 passed by the Court of Learned Civil Judge, Senior Division Morigao, in title appeal number 28/2025, whereby the said appeal was dismissed on being barred by limitation. Stop. After considering the submissions made by learned counsel for the appellant, as well as after going through the materials available on record, following substantial question of law is formulated in this appeal. Whether the first appellate court committed perversity in declining to condone the delay of how many days?
258 days.
258 days in preferring the first appeal against the judgment of the trial court by the present appellant, ignoring the statutory presumption contained in section 119 illustration E of the Bharatiya Sakshya Adhiniyam 2023. Stop. Issue notice to the respondent. The appellant shall take steps for issuance of notice upon the respondents. How many respondents?
Sole respondent.
Upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 12th August. List accordingly.
My lord, there is IA for stay of the execution, my lord.
Execution has been filed.
Execution has been, it is prior to appeal, my lord. During appeal, it was stayed.
Heard
And,
Mr. K.M. Haloy, learned counsel for the applicant. This application under Order 41, Rule 5 of the Code of Civil Procedure 1908 has been filed by the applicant in connection with regular second appeal number 86/2026, praying for stay of execution of the impugned judgment, impugned order dated 2/ stay of execution of the judgment and decree dated
24/1/2025.
24/1/2025 passed by the Court of Learned Civil Judge Junior Division Morigao entitled
This is not division number 1.
Number 1 Morigao entitled suit number 60/2017. Learned counsel for the applicant has submitted that
Title
And
execution
the-
case number 10 of 2025.
that the respondent has already initiated an execution proceeding, namely title execution case number
10 of 2025.
10 of 2025 before the executing court. And in the meanwhile, the regular second appeal filed by the present applicant has already been admitted and substantial question of law has been formulated. They did stop issue notice to the respondent. The appellant shall take steps for issuance of notice upon respondent by speed post as well as by usual mode within 7 days, returnable on 12th of August. In the meanwhile, considering the submissions made by learned counsel for the applicant as well as the averments made in this interlocutory application, further proceeding of title execution case number 10 slash, which is the year
2025.
2025
Pending before the court of
pending before the court of
Civil
learned
Junior Division number
Junior
1.
Division number 1 Moregaon shall remain state.
Much,
List accordingly.
much.
Hearing,
Posted any day, Lordship.
we don't have time to
Lordship, any day, Lordship.
heard Mr. A. Gogoi, learned Central Government Council appearing for the appellant. Also heard Ms. M. Kolita appearing for the respondent. Due to paucity of time, this appeal could not be heard today. List this appeal again on 10th of September.
Lordship.
Any short date, because I have received the decretal amount in this matter.
It was given in the protest, Lordship. Yes, because there is a order of the interlocutory application, Lordship. But unfortunately, the order was not signed by my.
You have already received.
We
But
have
suppose
received the
appeal is allowed, you may have to repay it back.
Lordship, even we have given it under warrant, Lordship. Warrant on Lordship, protest, Lordship. There is a Lordship.
Okay.
Interim
Not
order
10
was.
September is okay.
Lordship,
You have already received 10 September.
Lordship.